All right, good afternoon. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 15th. We have 8 bills on the docket, and we'll start off with Senator Castley with Senate Bill 652. We'll then go on to 777 with Senator Carter, 773, 817, 300, 745, 893, 676. So without further ado, we'll start off with Senator Castley with Senate Bill 652.
So if we bring up our panel?
Absolutely.
Mr. Chairman, colleagues, it's no secret that we have a statewide shortage of law enforcement officers. And this is of great concern to all of us because we know that our public safety depends on the selfless dedication and commitment of the amazing people who are willing to undertake the considerable personal risk and injury of death to render service to their community. I cannot tell you for certain, colleagues, what makes these brave people stand up. I personally believe it's a complex mix of courage, love, family support, faith, education, and community support. And while I can't tell you for certain what makes our law enforcement officers step forward, I can tell you, based upon my own personal experience and my time in the military, what will keep them from stepping forward. And that's a lack of support from our community and from this body. If we don't stand behind the people who would protect us, those good people will not stand in front of us. On December 16th, 2021, Baltimore City police officer Kiona Holly was targeted for assassination and shot while serving on duty. She was shot by a man who had been convicted of 3 armed robberies in 2006, sentenced to 15 years, and who was at the time of the shooting was awaiting trial for a March 2020 arrest for being a felon in possession of a firearm. Officer Holly died December 23rd, leaving behind to deal with the terrible loss her 4 children, her husband, her sister, and her parents. I'd like at this time to recognize those of her family that are in the audience. If they could just please stand real quick, if that's all right, Mr. Chairman. We've got her mother and 2 daughters and her sister are all present here in the hearing today. Thank you all very much. This was not a shooting that was done in the course of a crime to which Officer Holly had responded. This was not a bank robbery gone bad. No, Officer Holly was targeted and shot in cold blood and deliberation solely because Officer Holly was a police officer. Ladies and gentlemen, now it's our turn to respond to this horrible crime. It's vital that the General Assembly make a clear statement that we stand with our law enforcement officers and their families. Senate Bill 652 provides that those who target and kill police officers simply because they are in fact police officers will not be eligible for parole. They'll serve their entire sentence behind bars. This bill will not apply to those cases where, for example, a shootout occurs in the course of a robbery gone wrong. It specifically targets those who would serve the public. We've assembled a panel of Officer Holly's family members and friends and co-workers who I will defer to for further remarks. I would just at this time like to express to Officer Holly's family members present and those listening my deep appreciation for their continuing support for Officer Holly's brothers and sisters in blue. Thank you for willingness to testify here today. Thank you. If any members of the committee have any questions, otherwise we'll go ahead and let the panel start testifying.
Of course, Senator, whomever you'd like to have first.
Who wants to start off?
Sure.
You want to come on up here and then just stand right here and testify? Okay.
Good afternoon. My name is LaWanda Sykes, and Kiona Holly is my sister. I come before you today along with my mother, Karen Edie, Kiona's oldest daughter, Kajana Holly, and her 18-year-old daughter, Kalia Holly. I hope to leave you all today with an understanding of who my sister was and what she meant to her family, her friends, and the community of Baltimore City. On December 16th, 2021, I remember looking at the clock right before bed, and it read 12:34 a.m. It's funny to me because me and my sister always shared what we called angel numbers, what numbers that you read in sequence and you find meaning in those numbers. I thought to myself I hadn't called her that day, and I wish I could have because I didn't get the chance to have that last conversation with her. At approximately 1:30 that morning, my phone rang, and it was my mom telling me that the officers were on the way to pick me up because my baby sister had been shot. It was my worst fear, and I've been living in a nightmare since that night. On December 23rd, 2021, my sister lost her battle, and she went home to live with the Lord at 4:44 p.m., which is another angel number we shared. To me, that meant my sister had done her job, and she was at peace, and she was at rest. My sister was cheated of her life by two men who decided for whatever reason her life was not of value to them. They made the conscious decision to shoot her and take her away from everyone without any regard for all she left behind. My sister was a goal setter and constantly strived to complete whatever she set her mind to. It was no task too big or too small that she could not handle. I admired her strength and her tenacity to always move forward no matter what obstacles she was faced with. She worked extremely hard to become a police officer, and in a short amount of time, she was able to touch and reach the lives of the community in which she chose to protect and serve every single day. She would give of herself freely and generously to anyone who was in need. Kiana, like many officers, leave their families to serve the community and protect us every day with the hope that they will return home to those same families at the end of their shift. They take on a job that many would not be willing to do, to serve and to protect. My sister chose to take that job, and she wore that badge well. Becoming a police officer was not just a job for her or a paycheck. It was something that she looked to seriously and she took seriously. She went out every day and left her 4 children to make a difference within the community of Baltimore City. She lost her life in the line of duty, taken like a thief in the night by cowards who knew exactly what they set out that night to do. I do not know the reason why they did it, and we may never know. But I do know I will not allow my sister's death to be in vain. I come here today with my family in full support of the Officer Kiana Holly Public Safety Act, not just because she was my sister, but all officers who serve and protect our community every day and risk their lives deserve to have justice for them. The bill may prohibit someone else from making the terrible decision to ambush and murder another officer by implying stricter penalties for those crimes committed. My sister gave her life fulfilling a dream, and I will spend the rest of mine ensuring that she gets the justice she deserves. Thank you all.
Thank you very much for your testimony. I remember reading about your sister and how she joined the force because she wanted to change the system from within, and she wanted to kind of break down some of the barriers between race. And so the committee thanks you for being here.
Thank you.
Thanks.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, members of the committee. For the record, my name is Michelle Wurzberger. I'm the Director of Government Affairs for the Baltimore Police Department. In your file, you should have a letter from Police Commissioner Michael Harrison heartfully supporting this bill. He sends his apologies that he was not able to be here, but he has been in touch with Officer Holly's family and has told them that he supports this bill heartily and has asked me to be here to speak in his stead today. Thank you for allowing me to speak. I especially want to thank Senator Cassidy for his leadership on this very, very important topic. I want to thank Officer Holly's family for coming out to support this bill and for sharing their sister, their daughter, their mother with the Baltimore Police Department and the residents of Baltimore City. I want to be clear that their heartache is what makes this bill absolutely necessary. Officer Holly joyfully and intentionally decided to become a police officer to keep her community safe. That's what we want, right? Officers who enjoy doing their job, who enjoy serving as guardians, protecting their communities. The fact that she was killed while on duty, while in uniform, while in her patrol car, protecting her post is an absolute outrage. I will tell you that this bill is both professional and personal for me. Of course, I'm here to speak for the many thousands of officers we have working for the Baltimore City Police Department every day. But I'm also here to speak on behalf of my 27-year-old stepson, who is a young officer in Baltimore County Police Department. And I'm here for my 9-year-old and 6-year-old sons who want to follow in their fathers and their brothers' footsteps and become police officers themselves. Every day, can I just wrap up, Mr. Chairman? Every day we expect our officers to be braver than we are, to unflinchingly run toward the danger to keep us safe. We ask them to risk everything for us. The very least that we can do is to ensure if someone kills them simply because they wear a badge and a uniform, that that perpetrator will be held accountable to the greatest extent of the law. And for that reason, I respectfully but strongly urge you to report a favorable report on this bill. Thank you, sir.
Good afternoon, everybody. My name is Lieutenant Elliot Cohen. I'm here on behalf of the Baltimore City Fraternal Order of Police, Lodge Number 3, in support of Senate Bill 652. You know it's an important issue when the local lodge here is on the same side of the table with management. Police officers are the public face of government decisions. They are asked to enforce and carry out the laws that many of which originate from this committee itself. They put the uniform on every day without hesitation. They are the public face of our communities and a public symbol of order and a just society in our communities. When police officers are attacked and killed, it's not just a horrific tragedy for the families, it's also an attack on our communities themselves. These perpetrators are making the conscious decision to single out our symbols of a just and order society. They don't care about the community at large. They do not believe in an orderly and just society, and it's shown in their extreme acts. Because these criminals have decided to destroy our just and orderly community, they should not be allowed to enjoy the benefits of that society. They must be held for the full length of their punishment and not allowed out earlier than expected. It is one of the many reasons the FOP Lodge Number 3 supports Senate Bill 652, and we hope you vote it out favorably. Thank you.
All right, questions from the committee for the sponsor and the sponsor panel? Senator Carter.
Thank you, Mr. Chair. Please indulge me. I don't have a question. I just wanted to thank the Holly family for coming to testify. And also, my empathy is with you. And I did see the video from Kiana Holly that she posted, and it's very sad. She's exactly, as you said, what we want in a police officer. Thank you.
That's right. Well said, Senator Carter. All right, without further questions, thank you all very much.
Thank you.
All right, next we'll hear from Clyde Boatwright, Michelle Wurzberger, Sorry, that's right. Did Elliot Cohen, that was Elliot Cohen, right? And Don Helms. And that was it. Yeah.
Oh, okay. My name is Don Helms. I am the chaplain for the Baltimore City Fraternal Order of Police, and I'm here today to speak in favor of Senate Bill 652. We know that individuals who commit crimes see punishment as an occupational hazard. From the time when they're little and young, they're in and out of jails. They become accustomed to the situation and comfortable with the system. No matter what crime criminals commit, they believe that there is always an opportunity to get parole or something will reduce their sentence. For instance, it was learned that several years ago, judges were given improper instructions to the juries, which caused cases to be reopened and deals to be made. One of these cases was a sniper who killed a Baltimore City police officer, wounded 10 others, and he did receive life imprisonment with 60 years. A deal was struck, and now he will be out in 11 years. Imprisonment without a chance of parole can be a great deterrent. We have no adequate way to collect data to say why some individuals commit certain crimes and where others do not. The legislature, law enforcement, and the religious community must continue to come together to look for viable ways to protect law enforcement officers who are committed to protecting and serving the communities they work in. With demonization of law enforcement and manpower shortages, it creates a tremendous hazard for law enforcement officers to protect them in the communities that they work at. It also makes them a possible potential target. I will leave you with this. A philosopher once said, "The only thing necessary for the triumph of evil is for good men to do nothing." And the inspirational words of Martin Luther King, "Our lives begin to end the day we become silent about things that matter. To ignore evil is to become an accomplice to it." Thank you very much for your time.
Good afternoon, Mr. Chair, members of the committee. My name is Clyde Boatwright, and I'm the president of the Maryland State Fraternal Order of Police. I stand here in support of Senate Bill 652. As I was preparing to testify, I was going to initially say me too, because I knew some of the testimony would be powerful. And I will say Officer Kiana Holly's sister's testimony was very powerful for me, knowing that I got that same call at 1:30 a.m. And seeing this family at the hospital that night, and seeing this family go through the funeral process, seeing this family a few weeks ago down in Cambridge at the survivors retreat, and seeing this, knowing that this family has to now go through another process in May, where the National Fraternal Order of Police will honor Officer Holly and other officers throughout the country who have died in the line of duty on Fallen Heroes Day. To know that we have a chance to pass a law that will prevent this family from reliving this horror every few years because a person comes up for parole. We want to eliminate that opportunity, and we ask from the over 20,000, close to 21,000 members of the Maryland State Fraternal Order Police that you return a favorable report on this bill, and hopefully we can be a deterrent to those that decide to willfully injure police officers. So I thank you, and I stand for any questions.
All right, questions from the committee? Questions, comments from the committee? Mr. Boatwright, thank you very much.
Thank you.
All right, I think that will conclude the testimony and the hearing for Senate Bill 652. Again, to Officer Holly's family, just want to say thank you for taking the time to testify, and we're immeasurably sad for your loss, but I really enjoyed, I never got to meet her, obviously, but I've enjoyed reading the little bit that I did about her, and just that her story is very inspirational because she obviously joined to change things from within the system and to break down those barriers between communities of color and policing, and she's exemplary of a true public servant. So just thank you for taking your time, and I wanted to say that after I composed myself a little bit, so thank you. Thank you. All right. Thank you, Senator Castley. Now we'll move on to Senate Bill 777 with Senator Carter.
Good afternoon, committee. Almost hate to bring a bill right after that because I really felt the same as the chairman in hearing the testimony of Kiana Holly's sister. But nevertheless, this is an important bill that I'm about to present, Senate Bill 777. I'd like to bring up my panel, Rebecca Snyder from the Maryland Press Association, Matt Parsons from the Baltimore Action Legal Team, Yanet Emanuel from the ACLU, and Deborah Levy from the Office of the Public Defender. Mr. Chair and members of the committee, this bill is a fix to what we did last year in terms of passing Anton's Law. We meant for the public disclosure of police disciplinary records to be attainable to the public, and as a matter of the public interest, we meant for it to be attainable to victims. But what we have found, and there's articles that may or may not be attached in your files, but I'm happy to share them, that have come out that have indicated that there's been a myriad of obstacles presented by various law enforcement agencies and how they treat these requests for Public Information Act under Anton's Law. And so with that, I'll briefly read through my testimony, which gives a few examples, and then happy to take questions along with the panel. So Senate Bill 777, as amended, reinforces, oh, by the way, I forgot that part. It's amended, so the amendment should be in your file, but the bill no longer does what it initially did. It would actually make the public disclosure of these records free when it's a matter of public interest. So, as amended, it reinforces existing law by prohibiting law enforcement agencies from charging a fee for the search and preparation of a record found to be within the public's interest. The bill also requires the Governor's Office of Crime Control and Prevention to withhold certain funding from a non-compliant agency in the fiscal year following its violation. Last year, after much debate and a summer of nationwide protest against taking of Black lives by law enforcement, the General Assembly passed historic police reform legislation that included Anton's Law, a bill designed to provide transparency to police discipline and to bring the state in line with the majority of the country. Among other things, the law granted public access to police misconduct records for the first time in the state's history. Read in tandem with the Public Information Act, any person who has the right to inspect a misconduct record could expect to be charged a reasonable fee to obtain that record. Unfortunately, according to a multitude of public reporting and complaints to my office, some law enforcement agencies have been charging members of the public, including members of the press, unreasonably high fees to obtain the misconduct records. For example, the Montgomery County Police Department initially charged the Silver Spring Justice Coalition $95,000 for copies of disciplinary records. The Baltimore Police Department charged Open Justice Baltimore fees in excess of $100,000, sparking a lawsuit. Agencies in different counties have charged Baltimore public defenders fees varying from $10 to $500,000. This is troublesome and obstructive. I think we would all agree that police departments should welcome transparency and not shy away from it. They should be proud of the work that they do to protect and serve their communities, which includes not hesitating to demonstrate that they are not and will not tolerate misconduct. Ensuring a timely and cost-free release of misconduct records to individuals who have the right to inspect them is an important part of building community trust. When implemented as intended, Anton's Law will be the standard of police transparency for the rest of the country. By passing Senate Bill 777, we will further our efforts from 2021 to move Maryland one step closer to creating a culture of full transparency and accountability in law enforcement. For those reasons, I would urge a favorable report. Thank you.
Do you want to go first? Then I'll go first.
You should stand up at the podium.
Oh, of course. All right. Good afternoon, committee. My name is Rebecca Snyder. I'm the executive director of the Maryland-Delaware DC Press Association, and we are pleased to support the amended bill. This week is very timely for this bill because it's Sunshine Week. And Sunshine Week, the Press Association normally does a project. This year, we chose to look at the implementation of Anton's Law. Attached to my testimony, you'll see the reporting package that was done by Miranda Spivak, who is an award-winning journalist who has worked on these issues for several years. And she did a statewide analysis of what is happening in the implementation of Anton's Law. And as Senator Carter said, it is very rocky. It is uneven. It is also indicative of what we face in public records requests outside of police departments and across the board. So we firmly believe that public records in the public interest should be free. I know that's a tall order, that's a big ask, but it is so very critical and important. You're seeing in the reporting that Miranda did for us this past, for Sunshine Week, that it's not all bad news. There are departments that can release records in a timely manner and at a low cost. It's not a miracle. It's not just one or two. It can be done. And what this bill really does is says police departments must and should prioritize public records, accountability, and transparency. So it does bring forward the promise of Anton's Law. So I would urge a favorable report on the amended bill. Thank you.
Good afternoon, Chairman Smith and Vice Chairman Waldstreicher and members of the committee. My name is Deborah Katz-Levy, and I am the Director of Special Litigation with the Maryland Office of the Public Defender. Last year, I met many of you as you sat through a multitude of public work groups, meetings, hearings on Anton's Law. I believe that this group of people and the wider legislative body of Maryland passed Anton's Law because you carefully listened to the citizens of Maryland. You believed in it, and we trusted you to do the courageous work that you did last year. I'm here to report, a year past that legislative session, that the law is not going into effect in the way that we think it was designed to. I provided for you in my written testimony responses from different jurisdictions that we received after we submitted MPIA requests for documents that we think criminal defendants are entitled to. The Constitution requires. For example, in St. Mary's County, what I didn't give to you today are spreadsheets that we've gotten from some law enforcement agencies where they dictate that officers, I have from St. Mary's County, 14 sustained findings for a lack of truthfulness. I have reports of 14 sustained findings for a lack of truthfulness. Those are reports that we don't actually have, just the summary by law enforcement themselves finding their officers to be untruthful, and we don't have those documents which we think are constitutionally discoverable in a criminal proceeding. That's not debatable. We don't have those documents. From what we're getting are summarized, watered-down versions of the documents themselves, requesting files for 11 officers who we believe had sustained findings of fact in Howard County. They're asking to charge the Office of the Public Defender $2,973, Maryland State Police $4,804, Montgomery County $412,000, Tacoma Park $5,421. For the PG County Sheriff's Office, I actually had to go down on a Friday to pay a bill, to get a receipt to come back on a Monday to sit and view the files without any free time at all. It's been an unreasonable imposition of fees that is a workaround around the bill that we believe you intended to pass. Thank you very much.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. For the record, my name is Yanetta Emanuel, Interim Public Policy Director at the ACLU of Maryland. The ACLU of Maryland urges a favorable report on SB 777 as amended, which seeks to make MPI-requested documents that serve public interest free of charge and create a mechanism of enforcement of Anton's Law to ensure compliance. Last year, this committee passed SB 178, Anton's Law, which was a major step towards greater transparency and accountability in Maryland. As a result, members of the public, victims, and their families were given greater transparency and oversight of how police misconduct complaints are handled. However, various financial and bureaucratic barriers have challenged the successful implementation of this law, with some departments outright denying requests or demanding members of the public pay thousands of dollars in fees. You've heard the examples from this panel, and you have more examples in your written testimony. And I'll just say that these fees are especially ridiculous when considering that the requester, like many other organizations interested in obtaining these records, is a nonprofit with limited funds. Public access must be afforded to everyone regardless of their ability to pay. This financial burden means that public access is only afforded to those who can pay, and in addition to these outrageous fees, according to the Baltimore Sun article, individuals have come across a myriad of excuses as to why their requests cannot be fulfilled in a timely manner or at all. Many of these excuses amount to a purposeful refusal to fulfill the duties outlined in Anton's Law. These burdens are contrary to the spirit of the law that this legislator passed contrary to the spirit of the law that this legislator passed last session. This law cannot function as intended without some sort of method to ensure compliance, and as amended, SB 77 ensures that compliance mechanism. And so for the foregoing reasons, the ACLU of Maryland urges a favorable report on SB 777. Thank you.
Hello, Mr. Chair, members of the committee. I'm Matt Parsons, the community lawyer at Baltimore Action Legal Team. I'm testifying in favor of SB 777 with amendments. We've learned the Baltimore Police Department cannot police itself. We've learned this in Balt's own dealings with BPD from the Steptoe report and in hearing the experience of community members across Maryland. In the last 2 years alone, BPD made Balt take them to court 5 times for records. Balt was forced to resort to litigation because of their routine misconduct for the MPIA, such as unreasonable fees, arbitrary and capricious fee waiver denials, and undue delay of disclosure. 2 recent instances illustrate our experience working with BPD. In a recent case, we requested police misconduct files from July 1st, 2020 through June 30th, 2021. This comprised 3,247 complaint files at $424.78 per file. In the prior case, we requested similar records from January 1st, 2019 through December 19th, 2019, both period of a year. This comprised 769 complaint files at $208.96 per file. Between these 2 time periods, why has the cost per file doubled? On what basis? BPD has not provided a single clear answer. We have seen no good faith in helping us to resolve the issue or receive clarity. Instead, at every step, they attempt to obstruct disclosure. There are currently no mechanisms to deter such misconduct. The only available forms of recourse, such as attorney's fees or disciplinary action, are only available after lengthy, costly litigation that ordinary community members couldn't possibly afford. BPD may say there's too much time and money into fulfilling these requests, but that's not true, given their $550 million budget in 2021. That cannot be expected to be left to working class people. To reiterate, BPD cannot police itself. We've seen this with the Gun Trace Task Force, and the Steptoe report reveals nothing has changed post-GTTF. So if we want the GTTF not to happen again, we need transparency. Balt urges a favorable report on SB 777 as amended. Thank you.
Excellent, thank you very much. I had a question for Ms. Katz, because I mean we were on a panel together not too long ago over the summer, and I just wanted to kind of highlight, just bring forward the problem, like the technical problems you're having, because in July of 2022, we've got this board, this compliance board that'll be kind of up and running, whereby if you have a custodian of the records that has given you a denial, you can appeal that decision to this board and kind of have a decision from there. And we set up an ombudsman of sorts to kind of sift through some of this as well. So in Montgomery County, what are the problem? The problem is essentially the fee, or is it anything else? Are you being denied access to not even in Montgomery County, statewide, where your experience, since I know you're an attorney and practicing in this area, is it just the fee? And if not, what else? Could you just tease out what else are some of the hurdles? But then also, the fee, the custodian of the records, they're able to, I mean, historically, they're able to, whenever you do a PIA request, charge a reasonable fee. And I think that reasonable fee is a certain amount of money. It's like no more than, it's gotta be like $500 or something. And so, what is it? You can tell me, it's in the statute, or what is it?
It's a reasonable fee. They did set a limit for like photocopies
Yeah.
and things like that, and I think it's 50% per page or something like that. But that, when you're talking about body camera footage, it's a little bit different. What I hear, you may hear different things from your constituency, but I hear from journalists all the time about requests just kind of going off into the ether, literally never acknowledged. They're supposed to, a custodian, when they receive a request, within 10 days, they're supposed to reply back to say, we need more time, you can find it here, whatever the case might be. They're not getting their 10-day letters, they're not getting any acknowledgement, they're certainly not getting it within 30 days. And the ombudsman is lovely, and we're hoping that she will have more sort of enforcement or teeth come July 1, but it's difficult because it feels like it's so uneven. There are some departments that really want to do this, and there's others that just don't seem to care, or else you wouldn't have such a wide divergence in outcome.
So the Office of the Public Defender put requests out to every law enforcement agency across the state to, for officers who we found had civil suits or other reasons to believe there was something. So I've gotten 10-day letters from most agencies. So most agencies are acknowledging receipt of our request. Where the problem comes to us, for example, I put in my written testimony 2 responses from Montgomery County totaling over $400,000. Montgomery County is giving, for one officer, the document redaction estimate is $3,000, the media redaction estimate is $18,000. For one officer, they're telling us that the document redaction estimate for Officer Giovancini is $6,000, the media redaction estimate is $99,500. Tacoma Park is telling us that we have to actually pay the city attorney's hourly legal fee, $175 an hour, for the Tacoma Park city attorney, who's a private lawyer, to review the files to make proper redactions. Then you contrast that with other jurisdictions that are printing out. All you have to do is hit print on IA Pro, which is the document management system that most law enforcement agencies across the state use. Each officer has a summary. You can easily print an IA Pro summary for an officer to the tune of 0 seconds. And if there's any redactions that need to be made on that document, it certainly would not, it would come far under the 2 hours. When we put a subpoena in for a case, we get those back all the time as a matter of course from Baltimore. Baltimore can do that. Every agency should be able to submit an IA Pro summary. This is a resistance of will, not a resistance of actual reasons, in other words. So to give us this document and tell us it's going to cost, these 2 documents from Montgomery County, most respectfully, both your jurisdictions, the chair and the vice chair, to tell us it's going to cost $500,000, they've made no effort to comply. So we've gone back then and said, give us, like other jurisdictions, I shouldn't have St. Mary's County saying, we'll give you for free a printout of summarizing, and then you can come back and give us more detailed requests. I think that's fair. We'll do that. We'll go through and find fact sustains that we want. We'll work with these agencies. But other agencies, Prince George's County has given us absolutely nothing. Montgomery County is really sort of stonewalling. Rockville has come back, I think, with a spreadsheet. We're getting just such disparate answers. Everybody has the ability to give us an easy answer, with the exception of 2 jurisdictions out west in our state that didn't have IA Pro. And they're politely going back and saying, can we find these records for you? So I think that this is just a matter of will.
All right, thank you very much. We'll go to Senator Bailey and then Senator West.
Ms. Katz, I was curious, what is the fee that these agencies charge if you were asking for a police report other than one of these MPIAs? Let's say you were in an accident and you needed for insurance cost. What is that when you contact to get a copy of the police report? What I was wondering is if you have any knowledge about the difference in the fee structure, because I know they charge a fee there for that.
So thank you, Senator, for that question. I represent 100% of my clientele are citizens of Maryland who are indigent. So if I need a police report for an indigent defendant, I don't have to pay anything. If I need a record from court reporting under a certain amount of money, I don't have to pay anything. If I want to file for a petition for habeas corpus for an indigent client, I don't have to pay anything. And it should be the same when I'm seeking records that would go to somebody's constitutional rights in a criminal prosecution. It should be nothing. So across the board, those fees are generally waived for indigent defendants. So if that's my base. You could ask the other folks who have private citizens. I believe that a criminal defendant has a constitutional right to these documents, so there's a higher need for them in our particular circumstance. I think they should be public for everybody, but under no scenario should a criminal defendant have to pay for these records that they are entitled to by law and Constitution.
I don't disagree with your line of thought there, but at the same time, we have now opened something up that has never been opened to these police departments before. So they definitely, have administrative costs, they have personnel costs that they did not plan for before we changed this law. And I'm sure they're trying to figure out how to cover that. That's why I was asking. And if any of the other people that testified are willing to talk about their history when you need a completed case report, how much does that cost? And is that on the same guidelines of what they're offering now, or is this just completely unreasonable?
If I could just respond briefly, I think what we're working for is trying to help folks, and I don't believe that every agency in the state of Maryland doesn't want to comply. I've had the good fortune after sending these requests out, speaking to sheriffs, deputies, and heads of police. They call my phone and say, Ms. Levy, what are you looking for? How can we find, Ms. Katz Levy, how can we help you? And it is a learning process and a learning curve, and we're certainly willing to work with everybody to get there. I think this idea that agencies are going to, we have to do this full redaction for the body camera and this full redaction for the file, we have to meet somewhere in the middle and let them be willing to print out the documents they have, do limited numbers of redactions if necessary, and then come back for a greater request. In the real sort of boots on the ground, how does it work? I think that we can come to some better solutions before we start asking for these astronomical $100,000 redaction fees on body camera. We just don't need to get there yet. Do you know what I mean? So what I'm hoping is this body can encourage compliance even with the paper. Initially, this bill had a paper limit, so $500, 500 pages were going to be free. I read that as per officer or per incident. So you want to just start somewhere to help urge compliance. We're just a little too far afield from actualizing it. We're not trying to penalize folks, but we do know it's easier to comply if you just have a person printing out a report.
And if I could just add, I think that in addition to what was just said, that the purpose of this bill is to hold departments that are willfully not complying accountable. So to the departments that are reasonably taking time to gather these files, it wouldn't be applying to them. But if a judge finds that they were not in compliance, then they would be held accountable. And so creates that mechanism of accountability and enforcing that they actually comply with the law.
If I can just add one more thing. Of all the requests that we've put out across the entire state of Maryland, we've actually gotten 0 files. So we've only received summaries. In this entire year that I've been putting out requests to gather the files that we are entitled to, we have received 0 files. That is how strong the resistance is to the change that this legislature passed.
So when you say that the bill's set up for 500 page,
Originally it was. It's been amended.
okay. But if you had, let's say, 100 officers, and each one had 5 pages, that'd be 500 pages. But if you had 1,000 officers and each one had 5 pages, right, that's considerably larger number. But you say that 500 should be per officer?
Well, some files are enormous, depending, particularly, I've seen voluminous files in Prince George's County and in Baltimore County, the files that we get in court proceedings. So I think it would not be unreasonable to look at some files are that big, some are larger, some are much smaller.
Okay, thank you.
Could I please add some? Oh, sorry, could I please add something? Yeah, for a recent request for police misconduct files, Again, from July 1st, 2020 through the following year, we were entitled to 3,247 complaint files. We have not received any of the files. And I think also the larger point is that we don't even know how the BPD, for example, is complying with the MPIA and Anton's Law. We know that they're not giving us the files. We know that they're saying there is a specific fee. We don't know how that fee is being calculated, given that, again, that fee cost per file doubled from the preceding year. So there's even a lack of transparency about the process itself for complying with Anton's Law, and I think that it's important to consider that.
Thank you, Mr. Chair. I'm trying to deal with all these numbers. First of all, let me ask the sponsor of the bill. You said there was an amendment. I don't have an amendment in my packet. Can you describe what the amendment, how the amendment changes the bill?
The original bill, and it was kind of a starting point for me. This bill didn't come to me from advocates. It was something that I decided to put in because I received complaints from different people, and I wanted to do something about it. So the original bill had the first 500 pages of a request would be free. The bill as amended, which I don't know why the amendments aren't passed out in your file.
I have a copy, Senator Carter, if you want me to.
But at any rate, as amended, it does two things, as I testified to. It makes all of the responses free if it's a matter of public interest, and it also would have the Governor's Office of Crime Control and Prevention be able to withhold funding from non-compliant agencies.
So you're saying that the bill's been changed so that all the pages and all the information about the video is to be provided for free if it's a matter of public interest? How do we define matter of public interest? How do you define?
I think it's a broad term. I think that that's for the agencies are now making their determinations about what's releasable and what's not. I mean, I think it's arguable that it's all in the public interest. If that's what you're getting at. Is it very broad? Yes.
So the Maryland taxpayers should pay for copying all these documents and making, I guess, copies of the videotapes?
Look at it more as the Maryland taxpayers are paying for their law enforcement and having to pay copious amounts of money for their misconduct through lawsuits. And so this would actually, I think it would be a fee borne to the agencies that usually have quite a lion's share of the local budgets.
So the gentleman over there at the end of the table, the gentleman at the end of the table, I think just said, I think you said you would requested 3,200 and some odd files. 3,002, what do you, is this a fishing expedition? Why would you want 3,200 and some odd files?
Because there's the scale of misconduct with the BPD specifically.
3,200 and some odd policemen, you have reason to believe, have engaged in misconduct?
We didn't request that number of files.
You just said you did.
You know, for the PIA, you make a more general request, and then they tell you the number of files that may fit the scope of your request.
Well, the Baltimore City Police Department has sent us some testimony stating that last year they received a total of 2,592 requests. Were those from you?
Not all of them.
How are you deciding who you want all these files with respect to? Is it just a fishing expedition? Are you listing lots of policemen, or is there some reason why you would want these files?
We're trying to figure out why, corruption and misconduct exist in the BPD, especially after the Gun Trace Task Force, which you can learn about more in the Steptoe report. There's so little transparency around how the police department even functions that would enable corruption and police misconduct. And so I think it's also worth saying, again, the BPD received a $555 million budget for the fiscal year 2021, and yet in working with them on these requests, their staffing has frankly been very insufficient. And if they're aware that they are receiving, say, 2,000, you brought up requests, I think from looking at that budget, it seems like they would have the funds if they were to prioritize transparency to accommodate that.
Let me talk specifically about the videos. And we've been told that the video, every time a policeman has an interaction with a citizen, he has to make sure, or she has to make sure the video camera's on, right? Every single time. And the police departments can't simply hand out the videos. They have to have someone screen them, review them, redact information that needs to be redacted so that innocent people are not shown on film. So have you any idea how many hours of video would be available to be reviewed for any single police officer? My guess is it's a huge number of hours of video. And so you're claiming that the state needs to pay someone to review all those video hours in order to redact information that needs to be redacted just because you want to fish and see what you find with respect to that policeman. So the taxpayer should pay a lot of money so you can engage in a fishing expedition. Is that what you're telling us?
I would say if we were truly making a fishing expedition, as you say, the custodian would counter us and force us to make a more reasonable request, as is typically required.
But
under
I
the
think
PA.
in this bill, you want to avoid having to answer to a custodian who's making reasonable requests. You want to be able to tell the custodian, I'm entitled to everything free. That's what this bill says as amended, doesn't it?
If it's in the public interest, which in Baltimore Action Legal Team's recent case law from the Circuit Court and Court of Special Appeals in Maryland, they have specifically ruled in the context of Anton's Law that requests regarding police misconduct files within the scope of Anton's Law does serve the public interest. The Circuit Court stated that. The Court of Special Appeals affirmed that in the appeal case. And so I think the scope of this is actually more specific than you're making it out to be. We are not setting out to make fishing expeditions. Trust me, we do not have the resources. We're just a nonprofit in Baltimore.
Well, you're the one who said you're asking for 3,200 and some odd files
It was a time
in your
request.
testimony.
Yeah, we asked for files within a specific time request. They told us we have this number of files. That's all that happened.
Okay. Thank you.
If I could just add to that, the expanded powers of the MPI Compliance Board allows for custodians to to deny access to records if they believe that the request is frivolous, vexatious, or in bad faith. So to this fishing expedition that you gave an example of, if the custodian believes or the Compliance Board believes that the custodian is true in saying that this request is frivolous, then they'd be able to allow that custodian to deny that request. So I think there's something in place that is going to be implemented this summer that will kind of address the issue that you're giving an example to, Senator.
Senator, my understanding was the request from Balt was for a year's worth of files, so they would have no way to know that that was the amount of files, if I'm right. So they would have no way to know if they said, just give us the last year, so we can sort of do a look back and try to analyze how misconduct is developing and how corruption flourished, similar to the Steptoe report. And then they didn't know in making that request that it would amount to the number that you keep phrasing, which is over 3,000.
So to pursue it then, the request is for a year's worth of files.
That wasn't my request, that was the one that you were asking.
Okay, so all the video footage of those officers generated during the course of a year has to be reviewed by lawyers, expurgated before it can be released. Have you any idea how much it would cost to hire lawyers to engage in that kind of expurgation?
I'm glad you asked that question because it's important to note that, first of all, many times officers are disciplined for failing to activate their body-worn camera. And in those circumstances, which are multiple fact-sustained findings, which are then admissible in court when they again don't activate their body-worn camera, there is no body-worn camera. Lots of times officers are interacting with folks and you're assuming compliance with the law or the police department policy, but that's not always the case. I would say, in my experience, maybe half of them have body-worn camera, and there's a way to meet in the middle where you're getting at least the summary, the investigative documents, the statements that the officers gave, or even just the findings of the IAD board without getting all the way to the body camera. And I would find that it's oftentimes that you're probably not going to need the entire body-worn camera. In a fatal police-involved death, you're probably going to want to get all of the body-worn camera, and that would be in the public interest, I would think, if there's a closed investigation that people want to look at for some reason. But in your general run-of-the-mill complaint, you're not finding a tremendous, at least I am not finding. For example, let me give you a perfect example. I have a case in Baltimore right now where they have the IED files where 2 officers have said, this police officer is racially profiling people, citizens, and he's lacking in integrity and truthfulness in his policing. And they filled out reports and they gave specific examples for why this officer was causing caution to them. And then that officer had to be supervised by a major and a captain while he was working. There's no body-worn camera associated with those files. It's good that we got those files in criminal discovery. They're not being disclosed through the MPIA, but there's no body-worn camera associated with that. That's important information that we want to have. We want to encourage folks in conjunction with other laws that were passed last year to report misconduct by other officers. So, and there's nothing except for some reports and interviews in there, a few sheets of paper, super important, cost nothing, no body-worn camera.
Well, let me just say, it seems to me there has to be a happy medium between you're not getting any information at all, on the one hand, and you're being able to just go on a fishing expedition and ask for, by my count, 65 officers, and you want all the body-worn camera footage.
No, we didn't say that. They gave us back that. I agree with you. We should find a happy medium. I don't want to look at all that body-worn camera either. So we can have a happy medium where you start with the paper documents. Let me see what paper documents exist, and then I'll come back and tell you if I need the body-worn camera before I tie up your lawyers and your staff reviewing things that I might not need.
Well, that would make some sense, but that's
Yes.
not this bill as amended. Thanks.
Yeah, I'm listening to both sides here, and I understand, you're looking for a happy medium. The problem that I see from this body standpoint is, you can only take legislation so far, and then things become so fact-specific that, and it really requires an adjudicative body to sit there and say, give more, give less, give more, give less, unreasonable, not unreasonable, much like in discovery in any court case, who's gone too far, who's not gone too far. So I just don't see how we can prescribe, a more descriptive law, because at some point the words hit the facts and everything is my interpretation, your interpretation, his interpretation, their interpretations, and to try to, let's face it, sometimes people asking for information are totally unreasonable, and sometimes people of whom information is requested are ridiculously protective. And somewhere in the middle, for every document, for every move, for every video, lies that sweet spot. And it really is going to require, probably more often than not, a process. The old days where it was just give me your police file and you photographed what was there and that was it. You redacted the names of the witnesses. But we've moved so far beyond that. I know there's allegations, well, a lot of these things don't have the video cameras, and obviously we just mandated the video cameras, a year ago, so I wouldn't expect much in the way of video cameras, anything before we mandated it, because that was a hit or miss. If that cop happened to be one of the ones that had it, you got it. If they weren't one of the ones that had the equipment, you didn't get it. So I don't want to read too much into them not having the video cameras, especially prior to the date they were mandated. But I don't know how it seems to me we really are looking at a body that can, you appeal it, you come before, it's like a discovery dispute before the circuit courts, and you resolve it. Thank you.
Hopefully how the compliance board acts in theory to a extent. Go ahead, yes, go ahead. And
I
then we'll go to-
would say that you could look at this as an opportunity. Right now, the courts are saying it's all in the public interest and everything needs to be turned over for free. So if that's the direction that you don't want to go in, that's the direction that the courts are taking it right now without legislative intervention. So I guess you get to choose. If you do nothing, that may be the response that you get across the board, which I don't, for my constituents, I don't, my base of being a public defender, I don't disagree with it. But if what you're saying is how far do we go, perhaps going nowhere, respectfully, might be a problem too, because the courts are not siding, getting in the mix and just ruling it's in the interest of justice.
And I would add to that.
Just a general comment response to that. Quite frankly, the judiciary hasn't exactly been a willing partner in any of this either. So to suggest that, well, the judiciary says X, honestly, to me, when it comes to this body, that matters less and less with every year I've been here. So I'm not, the fact that they say it means this, quite frankly, we're that other branch of government, and I'm not really too persuaded more often than not these days when they chime in, so thank you.
You can hear the screams down Raoul Boulevard right now. All right, Senator Edelman, go ahead.
Thank you, Mr. Chair. And I'm sorry I was late to the hearing because I was in another committee on a bill. But I do think, I mean, with all due respect to my colleague, I think we spoke last year. I mean, we made this decision that these records were available, and that was our clear legislative intent. And so I guess I'd be really interested in this balance. I mean, we can't expect the police department or other law enforcement agencies to have a person dedicated 24/7 to going through the body cameras and to stand, by the scanner. So what is that happy medium? Is it a quantity of time? Is it expense? I mean, what is it?
I would think it's partly, it is partly meeting in the middle by narrowing requests, hearing from custodians about what they can do, and having that actually follow through. I'm stunned that no one here has gotten files at all on this,
Right, which I find totally unacceptable.
That is just out of hand. And what you're seeing in the reporting that MDDC did was, just a really uneven piece. So it is so hard to legislate culture. But what we're seeing over time, and this is not just police records, but it's all records, that there is sort of a hunkering down mentality on the part of custodians. And they are unwilling to say, if somebody comes in and a request might be, I would like to see all the paper files or summaries for misconduct in this period. Then you might, which should be a very easy press of the button, maybe, and that should be covered under the 2 hours. Not getting that, or not saying, well, we can't do that, but we can do this. You need to be willing to work with each side. Is that your experience?
It is, and I will say, Senator Hedelman, that when I started litigating with IAD files about 10 years ago, I was invited into the legal division for Baltimore City to copy the files myself. We've evolved to everything is now uploaded electronically, and I've gone into IAD offices and viewed files myself, and now they just have to download and send over a PDF. So there's no scanner, there's no copier, there's no printer. It is much easier. And I think by at least mandating compliance with paper documents, we would be getting farther along than we are now. And I mean, my colleagues would, probably not want me to say this, but maybe then you make a request to go back for the body-worn camera, and then you can talk about the time requirements for the body-worn camera.
Is there no back and forth right now with the custodian?
There is a back and forth. There just hasn't been production. So, for months, we've been getting, well, we'll get you a summary, or, well, we'll get you this, and I don't want to go to the ombudsman and the committee every single time, and I could file a lawsuit in all of these cases right now. I don't have the time, the wherewithal. I've got folks, presumed innocent sitting in jail. I've got other work to do, and the legislature spoke, right? So they should be producing.
And unfortunately, custodians sometimes are banking on just waiting things out. Like for news media, it's immediate, like if we can't get documents and move on, like that news cycle passes. And so it's worrisome to think that custodians are just running out the clock and saying, I'm just going to ignore that, or I'm too busy. We're all busy, but it is a priority.
Yeah, may I add? In terms of the back and forth, yes, there is a lot of back and forth. Balt has seen a lot of back and forth over an unreasonable, frankly, period of time with the BPD specifically. And the nature of the back and forth, it's not always a straight line. It's sometimes very contradictory seeming. Do you recognize our request is in the public interest? And yet you choose to, impose hefty fees despite that. You offer a fee waiver and then later on you deny it. There's no clear narrative. I think as far as what a balance is, who decides what that balance is? Is it going to be the BPD? I'm not inside of the BPD's offices. I don't know what their process is. All I know is what they're telling my organization, BALT. And so I think in terms of the PIA, may I remind the committee, the MPIA is to be liberally construed. It should err on the side of disclosure. I didn't even think it's being conservatively construed if we're not getting anything at all, you know what I mean? And so I think for a balance, we need to think about transparency at every level. And even in seeking transparency, there needs to be a transparency so that we know that there is good faith on the part of the custodian. Thank you.
So this process isn't in place yet, but once the compliance board is stood up on the 21st of July or whatever, so you have 10 days so you make a request from an agency, they have 10 days to acknowledge, hey, receipt of this, and then say, hey, look, we'll give you the material, or it's gonna take a little longer. Then you have an opportunity, or you will have an opportunity to appeal to the compliance board, and I forget what the schedule is there, it's 30 or, well, it's whatever it is, it's 30 to 90 days that they'll have to get back to you with a decision. What then happens? Is that when you would pursue litigation? Or what's the appeal to the appeal board? What's the other legal avenue after you've satisfied this administrative process?
So to be clear, the compliance board is already set up. It can only,
Understood.
however, rule
The
on-
jurisdiction expands into
Yeah,
this, sorry.
Exactly.
Yes.
And they still won't be able to do anything about fee waivers. So they can bargain you down, they can say that was an inappropriate exemption and so forth. They will do a binding, they can do a binding ruling, so compelling the disclosure, and then if that doesn't stick, then you file a suit.
Is it your expectation that that process will help give you some of that, because this veil that you're not being able to kind of understand what the ombudsman, let's say BPD, let's just say that, because it's where you're interacting. Do you think that that'll give you the type of relief that you're looking for through this process? Okay, I'm seeing some pessimistic nods, and we'll see how it goes, but, what are your thoughts? Because you made a comment about you not having an understanding, but I wonder if this process will give you a better window.
Yeah, so think about not being a fiscally sponsored organization, but being an average community member. All of this misconduct, say that happens to this community member. What are your options? You have very limited relief. If you choose to litigate, this is all after the fact of misconduct taking place. Litigation is extremely time-intensive, very costly for the average person. And so, you can't have the expectation that people will be able to experience harm to their right to access records that have been recognized as, being in the public interest. There needs to be more of a deterrent factor because that does not yet exist. If you pursue litigation, you may receive attorney's fees, for example. The PIA provides for a statutory fine of $1,000. There may be disciplinary action, but frankly, those have not been enough to prevent future misconduct, given the way that in the, again, 5 cases that we have taken against BPD, the nature and the scale of misconduct just seems habitual or routine. There's no option for deterrence right now or for meaningful recourse.
If I could add to that, I do feel like it will help. We were a strong proponent of that legislation last year. We wouldn't have been a strong proponent if we didn't think it would help matters. My worry, and I guess my gloomy concern, is that it doesn't, right now, with some custodians, not all, but some custodians are like, we're just not going to give you that information, and we don't care if that's legal or not, sue us. And so it's that culture of transparency that I get is really difficult to legislate. But we want to do everything that we can to bring that priority of accountability and transparency into all of our public records, not just police records.
Excellent. All right, thank you very much. All right, seeing no further questions from the committee, thank you all. All right, Robert Landau and Samantha Blau. And then we'll switch to the opposition panel.
Thank you, Chairman Smith, Vice Chair Wallstreicher, and Senators. My name is Robert Landau. I'm testifying on behalf of the Silver Spring Justice Coalition in favor of SB 777 with an amendment requiring that all fees be waived in the public interest. SSJC is a coalition of community members, faith groups, and civil human rights organizations throughout Montgomery County. We envision a state and county where community and individual needs for safety are met while harm by police is eliminated. Because of Anton's Law, we filed MPIA requests with 3 law enforcement agencies for the files of officers who killed or harmed members of our community in the past several years. We wanted to understand their story and the history and the consequences they faced for the harms they caused. Because we're a volunteer organization with no budget, we asked that the fees be waived. While the Gaithersburg City Police and Montgomery County Sheriff's Department did waive their fees without telling us what they were, the Montgomery County Police Department sent us a bill for $85,000, more than my bank account could cover. We were ultimately able to negotiate a resolution which we compromised on our request in exchange for a waiver of the fees, but this process has taken 5 months. This delay was exacerbated by a deeply problematic 10-day waiting period that MCPD negotiated with the local police union that required giving them an extra 10 days to evaluate the records before giving them to us. From these disclosures, we learned that 2 of the plainclothes officers who killed Kwamina Okran had been disciplined for other incidents and had also in plainclothes for just 18 months earlier. We also learned that 3 people who were killed because of mental illness crises were also not punished because of their shooting of those people. It's in the public interest to have this information. We cannot have it if all fees are not waived. We urge a favorable report. Thank you.
Just really briefly, so
Yes.
I'm just curious on your testimony, because it sounds like that you said you were out to make sure that the officers had, I believe you testified that they had been punished for the harm that they had caused. Did you have a dual mission to also thank and reward the officers for preventing harm, or was yours just a one-sided mission to punish police?
Let me clarify. Maybe I misspoke a little
I
bit.
thought you were pretty clear.
We just
but-
try to understand what the consequences were for the actions taken by the police, whether it was good, bad, or otherwise. We were seeking information.
Well,
We were
thanks for
not-
clarifying that. That's good to hear. Thanks.
Thank you very much.
All right, thank you very much. All right, with that, that'll conclude the testimony for the proponents of the bill, and we'll now switch over to the opponents, which will start off with Dominique Buchko, Bill George. And that's it.
Alrighty, thank you, Mr. Chair and members of the committee. Bill George with the Maryland Municipal League today in opposition to Senate Bill 777. I'm going to speak about the bill as introduced. We were unaware of amendments until, potential amendments until just now. The review and dissemination of police records in particular, I think was maybe a little bit, how do I put this? It's harder than it seems, right? I was told today that for body camera footage, which has generated a lot of discussion, it takes up to 10 minutes to review 1 minute of footage. Now, as more and more body cameras come online and more of their footage ends up in these investigative records into police misconduct, that's more and more footage that needs to be reviewed before disseminated. And there is liability to the local government should something not be shielded or redacted and then is let out into the public. There's recourse that some of the people who are identified or some of the records that are identified in the public record can come back to the local government if they were not redacted properly. When it comes to the 500 pages, I'm not quite sure how, I know this is in the original bill, not in the amendments, but how that would kind of interface with footage, which is measured more in time or file size, I'm not quite sure. And removing fees, we talked a little bit, or you talked a little bit about the back and forth between records custodians and requestors. When the fees are off the table, there's no incentive to have a back and forth discussion as to narrowing of the scope of requests if there's no reason for the requester to give on their ask if everything's free. So as more of these investigative records are available, as more body camera footage becomes available for, or subject to the Public Information Act request, our records custodians are overwhelmed and could use some assistance. We've been banging on the table for several years now about body camera footage in particular as it relates to the Public Information Act, and it's just manifesting itself one more time in this bill, and we ask for an unfavorable report.
Mr. Chairman, members of the committee, Dominic Butchko with the Maryland Association of Counties. First time in front of JPR, so it's a pleasure to meet all of you. MACO opposes Senate Bill 777. First, I'd just like to echo everything that my colleague from MML said. And as you heard from him and from the panel before, these are incredibly detailed reports that oftentimes lawyers have to spend countless hours' time going over. You're going to hear, and you've already heard, different ratios, 2 hours per page, 10 minutes per 1 minute of video, et cetera, et cetera. But the point is that these reports are incredibly detailed and can be incredibly expensive to produce. Public Information Act requests are just intensely involved, and you heard so much about the costs of preparing these. MACO has not been able to see the amendments, but from what I've heard today, the amendments take this bill from bad to worse, and the costs could just be absolutely enormous when we already have departments that are struggling with a lack of resources. Just accordingly, MACO echoes MML sentiments and issues an unfavorable report. Thank you.
Yeah, Mr. George, I found your testimony interesting that, and it was when I first started as a attorney practicing law, I tried to do pro bono cases, and I would not charge at all. And I suddenly realized that people who weren't getting charged at all were demanding far more of my resources than people who were actually paying. And I found that by just even charging a pittance, almost, close to pro bono, at least force them to economize on the law. And rather than go on for, 2 hours, they could summarize it in 15 minutes and move on. So you make a valid point that even having any fee, some fee, encourages people to think a little bit more clearly, prioritize, rationalize. So I appreciate your testimony on that. Thanks.
Sure. Thank you. And if I may just quickly respond, sir. The ability to go back and forth between the requester and the records custodian is something that has been going on for quite some time. And a lot of times the requester is, if it's not somebody who does this on a regular basis, for instance, may not realize the scope that they're asking for, right? And the records custodian can go back and say, hey, this will produce 3,200 police records if you want everything from the past year. Is that really what you want? And if so, this is approximately what it's going to cost you. And they say, my mistake, I don't actually need a year's worth. I'm actually really just looking for this one officer for a year, or only the past 6 months. And it really can, and I understand it doesn't work out all the time, and that's been made very clear, and that, that it's not a foolproof system, but it is something that can be beneficial both to the requester getting exactly what they want and the local government by being able to narrow the scope and cut down on staff time.
Thank you, Mr. Chairman. Can you explain how no requests were honored? 0.
No. I can't explain that.
It's not even one department, one jurisdiction. It's across the board, 0.
Mm-hmm. I understand, and that sounds like a bad number. It really does. It would be unfair of me to speculate as to why that's the case. I simply don't have an answer for you.
Okay, thank you.
Mr. Chair, so I appreciate your testimony, and you were here for the panel of proponents. And following up with Senator Hedelman's question, you heard that there is great disparity in fees that are charged, and you also heard that there are no requests being honored. And so I believe that even if the specifics in this bill are not the proper solution, there is something that must be done. And so my question to you is, what is your suggestion to ensure that agencies are honoring the letter and spirit of Anton's law, and that they are honoring the public interest request? What, if not this bill, what is your suggestion?
Thank you, Senator. I I didn't come in with necessarily a solution to the problem, not knowing the specific facts of what was proposed in the prior panel. I can say that one of the proponents suggested an idea of soliciting input from the records custodians and the requesting community, and figuring out if there's a path forward there. As I was sitting in the audience, I was looking a little bit at the PIA Ombudsman's website, and even their site acknowledges that they're a relatively new body, only 4-ish years old, and they're still soliciting feedback as to how they can improve on their interactions with both the public and the records custodians. So I think that there's an opportunity for dialogue here. I'm not sure removing the fees is the right answer.
Thank you.
All right, further questions from the committee? Seeing none, thank you very much. All right, with that, that'll end the hearing for Senate Bill 777. We are going to tack over to Senator Jackson. Senator Carter, if that's okay with you. Excellent, okay. So Senator Jackson, you're up with Senate Bill 817.
Thank you, Mr. Chairman. Thank you, Senator Carter, for your deference to an immediate past colleague. And it's good to see that JPR is working hard for citizens of the state of Maryland. Mr. Chairman, Mr. Vice Chairman, members of the committee, for the record, Senator Michael Jackson, District 27, on behalf of Senate Bill 817, which is employment of previously convicted individuals, state agencies, and youth camps. Senate Bill 817 is a very straightforward bill that simply creates a clear process for youth camps, such as the ones operated by the Boys and Girls Clubs, to better vet potential employees who have direct access to children. The bill would create a mechanism for the Maryland Department of Health to review the criminal background check information of those applying to work with children at youth camps. The Department of Health will be tasked with issuing related determinations to youth camp operators as to whether or not the results of said background checks will be prohibitive to hiring applicants. The aim of the legislation is to just make certain that if a job applicant has a criminal record, if there is no direct relationship between their conviction and their potential job duties. The legislation is simply a safeguard to ensure the health and welfare of our children and staff at privately owned youth camps in Maryland. And Mr. Chairman, you will be seeing an amendment. One will be dealing with a technical requirement related to fingerprinting, as well as requesting this bill be, should you feel fit to pass it, become an emergency piece of legislation, understanding that these camps are actually in the hiring process now to bring folks on board. So with that, I would ask for a favorable report, and I will stand with my panel for questions afterwards.
Good afternoon, Chairman Smith and members of the committee. I'm Maura Cyphers with Compass Government Relations here on behalf of the Maryland Alliance of Boys and Girls Clubs. We're here in support of Senate Bill 817. We understand from the Department of Health that some amendments will likely be necessary, but I think we definitely need some bill to pass because earlier this year we were informed by DPSCS that they could no longer transmit federal background check data to non-governmental employers. You've got that letter advising the clubs that DPSCS can no longer provide that information. And obviously, like Senator Jackson said, as youth development organizations, the Maryland Alliance of Boys and Girls Club works closely with children ages 6 and up, and safety is paramount. Their governing organization, the Boys and Girls Clubs of America, plus many of their federal grants require federal background checks, so they're in sort of a unique spot because they don't have a licensing board, like, for example, healthcare providers, and sort of lack that typical oversight home within the Maryland state government that most employers who do rely on federal background checks already have. So the closest thing, in our view, is the Maryland Department of Health. They are already licensing the club's summer camps, and so we believe that sort of that relationship, that technology, the ability to protect this data is there. They also run the CPS investigations and background checks that clubs rely on too. So we understand that any state agency will likely have to absorb this task, and we wish we had another option, but this is a federal law that unfortunately Maryland was in violation of when they were improperly providing this background data directly to employers. So the feds are requiring it stay within a division of government, and so we've asked the Department of Health, and I think they're willing to work with us. So thank you very much.
Good afternoon, Chairman Smith and members of the committee. My name is Lisa Lindsay Mondoro, and I'm the CEO for the Boys and Girls Clubs of Annapolis and Anne Arundel County, and I am here to support Senate Bill 817. The mission of the Boys and Girls Clubs is to inspire and enable all young people, especially those who need us most, to reach their full potential as productive and responsible citizens. Our clubs, and I speak on behalf of the clubs in the state of Maryland, are part of a statewide Maryland alliance, and we serve a growing population of more than 25,000 youth in our state. We focus on a high-quality club experience where youth and teens feel physically and emotionally safe within our buildings. We receive support from caring adults and mentors who focus on supporting relationships. We provide opportunities to try new things, have fun, and offer a sense of belonging to our Boys and Girls Club. We also focus on health and wellness, including more than 500,000 meals and snacks just this year to serve our clubs and our communities. And we have targeted programs which focus on education, career readiness, leadership development, social and emotional wellness, with a trauma-informed practices. The Maryland Alliance of Boys and Girls Clubs is part of a congressionally chartered Boys and Girls Clubs of America, which has very strict membership requirements for local clubs, which include background checks. Boys and Girls Clubs require chartered organizations to conduct criminal background checks every 12 months of employees as well as their volunteers who have direct support this bill. I can wrap this up. The change at the state level is a problem right now for federally not being able to receive federally background checks, and we appreciate Senator Jackson for stepping in to help us out, and we need to run federal background checks. We not only want it, but we need it. And since the Maryland Department of Health has already licensed clubs for summer camp and the Child Protective Services requirement, it makes the most sense for us to continue to work with them. Thank you.
Excellent, thank you. Usually when the buzzer goes off, we like to cut people right off, but your testimony was so good, we just kept going. Just kept the party going. All right.
It's for the youth.
All right. Questions from the committee? All right, seeing none. Thank you very much. Thank you. Thank you, Senator. All right, next we'll go on back to Senator Carter with Senate Bill 773.
Chairman Smith, members of the committee, I'm about to make all of us very happy, I think. This is my last bill to present for this session. Trust me, I'm as happy as you are. I also have good news on this bill. I've been talking with various people of interest, persons of interest and stakeholders, and the bill has been amended. Senator West, this time, the amendment really ought to be in your packet. The other one I found out wasn't yet finalized, so it wasn't in. But so this one is in your packet. So first I want to bring up my panel, who should be John Pica, Melissa Ladd, who hopefully are here. And so this bill started off as a storage bill, a safety storage bill, and it was my idea of a reasonable response to a media report of a gun thefts at a gun shop. And it was initially a bill that would have required certain safety measures, including voltage of these guns. But I talked with various people. I realized there were a lot of issues and problems with the bill as originally drafted, and it had likely no chance of passage. So we talked about other ways that we could achieve a better result when it comes to gun safety, and rather than penalize, to incentivize people to keep their guns safe. So with that, I'll give my brief testimony, refer to the witnesses, and happy to answer any questions. This bill now, as amended, is a tax incentive bill where people would be able to earn a tax credit for implementing the safety measures for their guns as in the bill. We all agree that the epidemic of gun violence in our country must come to an end. Unfortunately, across Maryland, we've seen a rise in firearm misuse, leading to the painful destruction of lives and communities. A storage vault, such as a safe, ensures that a gun is accessible only by its owner or an intended user, and protects the safety of families and children. Throughout the country, states of varying political leanings have implemented a similar tax credit. Massachusetts, Maine, Connecticut, New Jersey, Washington, and Michigan all offer financial incentives for safety devices. Joining these states will solidify Maryland's commitment to firearm safety. As one senator said, if guns are not stored properly, tragedy can come when we least expect it. Introducing a tax credit is one practical way to encourage and promote good gun safety habits. Senate Bill 773 will encourage better home safety, the reduction of unauthorized use and accidental discharge, and an increase in the purchase of convenience storage devices. Estimates show that 30% of Marylanders lawfully own a gun, with 103,109 registered firearms in the state. From 2019 to 2021, the number of applicants exponentially increased at a rate far above population growth. Between 2012 and 2017, individuals stole 15,924 guns, costing an estimate value of over $7 million. People did not just steal guns from off the streets. 674 firearms were stolen from dealers. We must regulate gun safety through common sense legislation that does not create substantial burdens on owners. In 2021, burglars stole 21 guns from a Harford County pawn shop after driving their car into the building. By the time police arrived on the scene at 5:15 a.m., the thieves were already gone. 30 years earlier, robbers stole 15 guns from Baltimore County gun shop in just minutes. Had storage vaults been utilized in either of these cases, guns would not have been on the street and possibly in the hands of criminals. Utilizing gun safety measures are an easy and modest way to ensure community protection. This is a small price for community safety. We must ask ourselves, how much is one life worth? For all of the reasons stated, I would ask for a favorable report on the bill as amended. Thank you.
Either Ms. Latter or Mr. Pica, whichever one you want to go first. Whichever.
Yeah, Senate.
Sure, go
Would you
ahead.
like me to
Sure.
testify?
Yep.
Thank you, Mr. Chairman. John Pica, on behalf of the, pardon me. I just lost 5 seconds. John Pica, on behalf of the National Shooting Sports Foundation. I'd like to thank Senator Carter for working with stakeholders and for the first time bringing together individuals who own firearms and those who seek to limit them. I'm happy to be at the witness table with a young lady with a red T-shirt on. That shows the consensus on this legislation. This amendment would incentivize and motivate gun owners to purchase safety devices that would range from a trigger lock to a safety vault in their home for the protection of minors and others in their immediate environment. 8 states, as Senator Carter mentioned, have a sales tax exemption. This does a little bit more than that. This is a tax credit. If there's a budget issue, and I'm assuming that the chair would have a discussion with the chairman of Budget and Tax, but this could always, if it's too expensive, this could be effective in fiscal year 2024. And you can also tweak the amount. So right now, it's a $500 tax credit. That's a relatively high number. If the budget figures are too high, you could reduce that somewhat to make it more amenable to the state, to the budget. So with that, Mr. Chairman, I would ask for the favorable adoption of the committee of the amendment. Thank you.
Good afternoon. And for the record, many of our volunteers are also gun owners, so we are, just to put that on the record. So good afternoon, Chairman Smith, members of the committee. My name is Melissa Ladd, and I live in Olney in District 19. And I am here today in support of SB 773, and I ask for a favorable report out of committee as amended. SB 773 provides a common sense provision to reducing the amount of stolen guns in Maryland. Maryland gun stores are vulnerable to robbery, as evidenced by a growing list of incidents. In March 2017, a gun shop just down the road where I used to live in Rockville, 30 guns were stolen in 90 minutes. And shockingly, that same gun shop was robbed again in June 2019, and at least 10 guns were stolen. In June 2019, a shop in Howard County was also robbed of 18 guns. In August 2019, a store in Essex and Baltimore County, 6 guns were stolen. October 2020, in St. Mary's County and Mechanicsville, numerous guns were stolen. The amount is unknown. In March 2021, in Waldorf and Charles County, this was the shop's second burglary. Unknown, quote unquote, number were stolen. December 2021, in Harford County, as Senator Carter mentioned, 23 guns were stolen. As you can see, this is a problem across all of our state, and the current security is not sufficient in some gun shops. If we want to keep firearms out of the hands of criminals, as many of your bills work on in this committee, encouraging gun shops to store firearms securely will provide an extra barrier against theft and loss. Thank you for your time.
Well, Senator Carter, you've done it. You brought the two sides together. That's a good job. Senator Huff, did you have a question? All right. Well, thank you both very much. Thank you. I know you were, Ms. Ladd, you were with us today. Was that with you with us in the gallery today?
That was.
You've been here for that. Thank you for being here. Thanks.
I guess we'll be back tomorrow.
Well, we are on the cusp. Yes. So yeah, I think we'll make some big progress tomorrow. Okay.
Mr. Chairman, may I
Yes.
just say that there was testimony about for the favorable report of the bill, and had I known that we were doing that, I would have had a different message for the committee. So it was my impression that we were testifying on the amendment and
That's
not the
correct.
bill
That's correct. Yeah,
itself.
absolutely.
That's
Yeah,
correct.
yeah,
Okay.
yeah,
Thank you,
absolutely.
sir.
Yes,
Thank
yeah.
you very
Just to be clear, that is correct. That's right. Yeah. And everyone's in agreement. So there you go. All right. Well, thank you very much. Thank you all very much.
Thank you, Mr. Chairman.
Oh, Senator West, sorry.
We
You almost got away.
I just wanted to express the hope that next year, Senator Carter, all your bills come to us in this posture.
Keep hope alive, Senator West.
All right, well, that then concludes the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we'll bring up Mark Schneider, John Jocelyn, Mark Pennick, Cynthia Belkov. It's Frank Boston here. Ari Platt. DJ Spiker. All right, whomever would like to approach the podium.
Mr. Chairman, thank you. I'm Mark Pennick. I'm the president of Maryland Show Issue. We received the sponsors' amendments this morning, and we are changing our position on the amendments to favorable. So we favor this bill as amended. And I will add my enthusiastic support for the bill. For the first time, I've actually seen the proper approach to these sort of issues by incentivizing people to do the right thing rather than putting them in jail to do the wrong thing. This will work, and I encourage the committee to wholeheartedly support it. Thank you.
Do you all hear that? think an angel just got their wings. Yeah, I don't know what's going on here, but, all right. Yeah, it's just, and then we get Mr. Jocelyn up here, all right. Don't ruin it for us, all right, here we go.
Good afternoon, Mr. Chairman, members of the committee. In the summer of 1980, I was project manager on a fire protection job in Calvert Cliffs Nuclear Power Plant. My counterpart with catalytic was a guy named Chuck Bergen, and we would sit at job meetings and go through the requirements we were given, and Chuck would sit back in his chair and he would say, "Lord, why is it some people refuse to let logic and common sense prevail?" Chuck Bergen is smiling today, because with this amended version, logic and common sense did prevail. We do appreciate the amendment. We do support the bill. We do hope that you report favorably on it, and we do believe it is a positive way to move forward. Thank you so much.
Chairman Smith, Vice Chair Waldstreicher, DJ Spiker, the National Rifle Association. It's great to be before you. This is my first time at JPR in person. I've testified previously virtually, having adopted Maryland as one of the states in my portfolio during the COVID in 2020. Appreciate being here. I'm glad to be here on good terms, similar to the postures of Mr. Jocelyn, Mr. Pennick. We also received the amendments this morning. We certainly do encourage the committee to adopt a favorable report. We support the amendment. We hope this committee will issue a favorable report. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, esteemed members of the committee. My name is Ari Plout. I'm here from Boston Plout Law here on behalf of the Maryland Licensed Firearms Dealers Association as well as the NRA. We did oppose the bill in its original form, but now we obviously support the bill, and we thank Senator Carter for amending the bill and for sharing the amendments beforehand. So with that, we support firearm safety. We believe this will help incentivize firearm safety. And thank you. We ask for a favorable on the bill as amended. Thank you. And I think, and Mr. Chair, I think Donna Worthy may have signed up. I'm not sure if it was on the sheet.
Hello, Donna Worthy, the president of the Maryland Licensed Firearms Dealer Association and owner of Worth a Shot Firearms in Millersville, Maryland. We also just got the amendments this morning, so we were opposed to the bill as written, but we are now in favor of the amended bill. Thank you.
All right, excellent. So, Anna, is Mike here, or is it actually?
Mark is not here. He was on Zoom.
Understood. Oh, got it, okay. And then I think we have two more folks. Mike Doherty and Mike, you said, is off on his Zoom. Okay. Have I missed anyone that's here to test? Michael Burke she just said this is on his Zoom. Okay, we'll go off to Senator West and then Senator Sidnor.
Thank you, Mr. Chair. I just want each of the people who just testified to remember this moment. May it be repeated in the future.
Amen, Senator.
Thank you. How many firearm dealers do we have in the state of Maryland?
Approximately 750.
Thank you.
All right, further questions from the committee? Excellent, thank you very much, and thank you, Senator Carter. With that, that'll conclude the hearing for Senate Bill 773. We'll now move on to Senator Huff with Senate Bill 300, or you can go with Senate Bill 745, which... Yeah. All right, this is Senator Huff with Senate Bill 745.
Well, thank you very much, Mr. Chair, members of the committee. There will not be consensus on this bill, as there has not been in a long time. Actually, this will be my last year carrying it. Hopefully it passes. If not, hopefully someone else picks up the torch. I remember as a staffer, Senator Hafer had the bill, who's from Western Maryland, and Senator Norman had the bill. I picked it up because I think this is a great bill. It's all about freedom. Senate Bill 745 would allow a person to ride a motorcycle without a helmet if they are at least 21 years old, have been licensed to operate a motorcycle for at least 2 years, and have completed a motorcycle safety course. This will return to motorcycle riders the freedom to choose whether they want to wear a helmet or not. And so, as I have in the past, I wrote down some I think, some good philosophical points about this. There's the philosophy behind this, which you have to decide on everything, and then there's also the data. So actually, if you look at, there's one thing the French get right. In the Declaration of Rights, they state, liberty consists in the freedom to do everything which injures no one else. Hence, the exercise of natural rights of each man has no limits except those which assure to other members of society the enjoyment of the same rights. In the context of this bill, we return to motorcycle riders the right that does not injure anyone else. Individuals should be able to choose whether or not they think a helmet is necessary for their own safety. Just like we make the choice whether you want to ride a motorcycle or not. I choose not to ride a motorcycle. I make a lot of choices what I think is best for me, but I don't impose those on other people. Another quote I think is relevant is from On Liberty by John Stuart Mills. He states, "The only purpose for which power can rightfully be exercised over any member of a civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not sufficient warrant. He cannot rightfully be compelled to do or forbear because it is better for him to do so, because it will make him happier, because in the opinion of others," many of those people are signed up here today in opposition, "to do so would be either wise or even right." Most of us will never or will probably never ride a motorcycle, but I would say we should not substitute our judgment for the men and women who are here today who regularly ride motorcycles and just want the simple freedom. And if you look, the other argument is on the, well, let me get into the other states. Beyond the philosophical argument, I'll get into some statistics. Maryland is actually the minority of states that require all riders to wear a helmet. Currently, Illinois, Iowa, and New Hampshire have no motorcycle helmet law whatsoever. 28 other states require some motorcyclists to wear a helmet. If this bill were passed, we would join those 28 states. Pennsylvania and Michigan are states that have the most similar requirements to what I'm proposing. And just to be honest, we've been in here over the years this has been put in. They've offered up everything. They've offered up, they'll carry insurance. They'll carry insurance to mitigate this idea that they're going to be a cost or drain on society or drain on the state. They've offered insurance riders carry up $1 million. So that argument, quite frankly, doesn't hold weight. And you look at the data, quite frankly, you can cherry pick the data whichever way you want. But if you look at the most recent data on motorcycle fatalities from 2019, compiled by the National Highway Traffic Safety Administration, in 2019 there were 75 motorcycle fatalities in Maryland. 66 were wearing helmets and 7 were not. 118,277 motorcycles were registered in the state of Maryland. That equals a fatality rate of 0.063. In Pennsylvania, which has a significantly larger population, there were 176 motorcycle fatalities, 377,158 motorcycles registered in that state, a fatality rate of 0.047, lower than the state of Maryland. Pennsylvania doesn't require you to wear the helmet. Maryland does. They had a lower rate. Looking through years of statistics, there's no discernible pattern that shows states with a universal helmet law are safer. I even looked at their statistics. Shock Trauma came in and said that in states that have it, 57% of the fatalities didn't have a helmet. What's roughly 50%? And they came back in Maryland and said, well, 9% of ours. Well, yes, we're a universal helmet state. The Governor's Highway Safety Association released a report in 2017 that showed that between 2016 and 2017, the Maryland motorcycle fatality rate was unchanged, but Virginia, which has the same law as I'm proposing, at Pennsylvania and Michigan saw decreases in theirs respectively. So passing this bill will not endanger public safety. It will return to motorcycle riders over the age of 21 who've been driving for 2 years and have taken a course the freedom to choose whether to wear a helmet or not. And I have one last thing I'll show you. When this came up 2 years ago, somebody brought up, I know it, they said, it's great to envision the idea of Easy Rider. And actually, it made me think of that movie. I brought here the picture so you all can see. And why is that picture so great? Is Peter Fonda there? You know, he's choosing not to wear a helmet. His helmet's back there. You see the wind blowing through his hair. Dennis Hopper there. But you know why it's great? Because that's America. It's classic Americana. People with liberty, freedom. That's what America's about. At some point in this country, we've gotten away from that. We've gotten away from it that all the experts, all the people back here who are going to testify against my bill, they know better for you, how you should live your life. And quite frankly, the data doesn't bear that out. I just lay that out to you. Look at the other states that do it, and let's return to people the freedom and liberty they should have that made this a great country. Thank you. I'll take questions. I'm sorry. If there are any. Okay. What'd you say? That's a different kind of liberty. That's a different kind of liberty that may be. That's a different kind of liberty that may be extended in a constitutional amendment coming up here, Miss.
Thanks, Senator Huff. I appreciate the picture, but Peter Fonda has way too much hair. I actually had two gentlemen visit me yesterday about this bill, and I appreciate it. I used to be a huge motorcycle enthusiast, and I told them that I would comb through the data, and you comb through the data as well. But let me give you the flip side of the data. I understand the argument about, the freedom to choose to wear a helmet or not. But my analogy, and I like analogies, is with seatbelt laws. And it's not so much about what the motorcycle rider does, it's what the other person does that puts the motorcycle rider in danger, and in more danger because they don't have a helmet. Now, the statistics that I saw about motorcycle deaths in Maryland from, and it's a little dated, 2013 to 2017, there are quite a number of wrecks of motorcycles. But over that 5-year period, the highest number of motorcycle wrecks occurred in Prince George's County, 14.5%. Baltimore City accounted for 13.1%, and another 10.4% in Anne Arundel. And so my question is real simple. While I absolutely understand your logic, I do want to look at it from the ability to ensure motorcyclists are protected from other folks on the road. Can you respond to that?
Yeah, I guess my point is this, and I brought up earlier, I don't ride a motorcycle. I made the choice not to.
Too much hair.
Yeah, well, I don't have Peter Fonda level hair. But it's funny you say that because my father was actually run into somebody. He was riding a motorcycle on the Beltway back when I was real little. It was actually in Prince George's County on the Beltway. He was run into, somebody was drunk and ran into him. But when you start down the path, the same arguments you're going to hear today against this bill are the same arguments we should make of banning motorcycles. They're exactly the same. The risk in that when you ride a motorcycle is inherently riskier than when you're in a car. So if we're here banning inherently risky behavior, shouldn't we simply just ban people from being able to ride motorcycles? Because it is obviously far more dangerous than if you're in an SUV. You put yourself at greater risk. So I think people who are adults, this is people who are 21 years old, they've gone through the training, we should just allow them to have the responsibility to decide. They know they're taking on the risk. You know when you get on a motorcycle, it is far more inherently risky than if you get into a large SUV and you're on the Beltway. And so we allow that risk, and I think we just should simply allow adults to make adult decisions. So it does come down to philosophy, because I'm telling you, the data, and I have the studies and all that stuff, and you'll hear the people that come up here against it with their data. It's all over the place. But there's, like I said, the majority of states are allowing this.
Thank you. You had mentioned the different proposals that have been offered in the past. I'm curious, one that you had mentioned was with regards to insurance, but it's not in this bill.
It's not, and we've offered that as an amendment, and I'd be glad to take that as an amendment. If that's one thing we've talked about in the past, is requiring certain insurance requirements and things like that. I'm happy to do that to move this forward if that's what the committee feels is necessary. And that's one of the provisions we've discussed in the past.
I was just curious why not have it in there from the.
Well, I mean, I think the bill as it is right now is adequate and correct, but like I said, I'm happy to do that.
Thank you.
Senator Bailey.
Senator, sorry I stepped out for a minute. Did you include that? I thought just 2 years ago or 2 or 3 years ago we had pretty much. I thought we had consensus and had fixed this. But we got it through the Senate, but we didn't get it through.
No. This bill has not come out of, it's not been on the Senate floor in a long time.
Okay, all right. Well, hopefully we can get it there.
All right, any further questions for the sponsor? Seeing none, let's bring up the next panel. Mr. Sawyer, Mr. Spanberg, Mr. Teo, Mr. Pugh. Oh, I'm sorry, I went into the unfavorables accidentally here.
Well, they could come up, Senator. They could come up with it.
Mr. Sawyer and Mr. Spanberg.
Sit next to one another. Good afternoon, Vice Chairman Wald Stryker, and I'd like to thank Chairman Smith for holding this hearing today. My name is Robert G. Spanberg, Jr. I'm the Chairman of the Board of ABATE of Maryland. I've been riding a motorcycle. I've had a motorcycle endorsement on my license in the state of Maryland. This will be my 40th year. I started riding in 1983, and there was no mandatory helmet bill in Maryland at the time. I rode for 10 years with freedom of choice in 1992. The mandatory helmet bill was enacted under false pretenses. I won't get off into the weeds about that. If anyone has any questions about it, I'll be glad to address it. But before I get I realize I only have 2 minutes, but I wanted to address what Senator Bailey said about you thought we had this. We actually had enough votes in this committee to get this bill passed out onto the floor, and the current chairman refused to let it be voted on. Was it a problem, actually? I went around and talked to every member of the committee, and we had enough votes to actually get it to the floor. But it's like that movie. There's 8.5 million ways to die in Los Angeles. There's, as you all well know, there's 1,000 ways to kill a bill in this town. But I just would like to thank you all for listening to us today. There's certain issues about this that I would like to address, but we sent you a package around the numbers, as Senator Huff said, really don't support mandatory helmet use. I like what he said about personal liberties and freedoms. That's what I've been about. I've been down here every year. I'm sure a lot of you recognize me for coming down here previous years talking about this. This is important to me, and if this doesn't pass this year, I'll be back next year to try it again. If anyone has any questions they'd like to present me with, I'd be more than happy to answer them.
Thank you. Let's have Mr. Sawyer testify, and then we'll have you both answer
all right.
questions if
Thank
they have.
All right, we're good. Mr. Chairman and members of the Judicial Proceedings Committee, I thank you for the opportunity to come in today and testify on Senate Bill 745. I'm Kenneth Sawyer, the Executive Director of ABATE of Maryland, and we've been fighting for this bill since 1992 when it was changed. The reason it was changed is because of the federal government imposing federal highway funding to states if they change to a mandatory motorcycle helmet law. That started in 1966, and 8 years later, 47 states have caved into the federal government to get that money. And money's important. We all know that it's important to take care of our roads. But they continually change back and forth in their fundamentals on these issues. And they say that we're going to give you funding or not give you funding. So this bill has gone back and forth, or excuse me, the mandatory helmet has gone back and forth across the country over the last 25 years. And it's because of the funding. It's always about money, follow the money. This bill is presented numerous times, and the opponents to providing helmet choice cite safety as their main reason. I, like Senator Huff, believe that a person should be able to make their own decisions. The Motorcycle Riders Foundation and the American Motorcycle Association, the two largest motorcycle rider organizations in the country, support helmet choice. We're not a radical group. We're not the people that you see in Baltimore County and PG County riding down the middle of the Beltway, riding wheelies and doing all that, and I know not wearing helmets that then are the deaths that are caused from people not wearing helmets. When was the last time, other than those incidents, did you see a person riding without a helmet? Thank you very much, and I would love your support on Senate Bill 745.
Questions for the proponents of the bill? All right, seeing no questions, we'll move to the opponents of the bill. Thank you,
All
gentlemen.
right, thank you very
Really
much.
appreciate it. Eric Teo, Brian Pugh, Kenneth Bragg, Maura Rossman, Gary Schwartzbauer, go ahead, whoever would like to go first.
So I guess I can't say Chairman Smith, so I will say Vice Chairman Waldstreicher. Good to see you. Members of the committee, my name is Brian Pugh. I'm the Executive Director of the Brain Injury Association of Maryland. We asked this committee to render an unfavorable report for SB 745. For 39 years, the Brain Injury Association of Maryland has been providing the free information and resource assistance to Maryland families affected by brain injury. In our written testimony, you will find numerous studies describing the virtues and benefits of universal helmet laws and the wearing of helmet while motorcycling. But if this issue was about improved public health, as reflected in federal and state grants, studies, and graphics, we wouldn't be here today. This effort is about feelings. The feelings of the wind in your hair with the open road before you. The feeling of personal freedom unencumbered by a clumsy, messy helmet. There is no safety report or statistical graph that can compete with feelings. But if this bill is about feelings, I at least ask you to consider the feelings of overwhelm and hopelessness of the people not riding the motorcycle. The feelings of the mother who must now find a nursing home for her injured adult son that will take his form of Medicaid or Medicare and tolerate the mood swings and violent outbursts he's had since his motorcycle crash. I ask you to consider the feelings of the wife whose husband is having to relearn how to walk and talk and feed himself, and who is now in jeopardy of losing her job, and with it, the family's health care. These family members are dealing with some of the most emotional and challenging decisions of their lives, and their loved ones were wearing helmets. These stories would have been much worse had they not been. So when considering this bill and the feelings of the aspiring unhelmeted riders, please also consider the feelings of the families that will not be given a choice if their loved one chooses not to wear a helmet. Please render an unfavorable report for SB 745. Thank you.
Good afternoon. Thank you for allowing me to testify. My name is Dr. Maura Rossman, and I'm the Health Officer for Howard County Health Department, and I'm representing the Maryland Association of County Health Officers. MATRO strongly opposes SB 745. Public health policies are steeped in science and data. The data from health and traffic safety experts in this area are irrefutable. These are the facts. Helmets reduce the risk of death by more than a third and the risk of head injury by more than 2/3. Helmets save more than $1 billion each year in the United States. The failure to wear a helmet impacts the entire community, not just the individual. Helmets do not limit the rider's ability to ride and do not reduce visibility nor impair hearing. There should be no confusion about the price we all pay when helmet laws are repealed or become partial. Universal helmet laws save lives, prevent injury, and save money. This is not true for partial laws. Nationally, riders 30 years of age and older account for more than 70% of all motorcycle fatalities. More riders over the age of 50 died in 2019 compared to riders under the age of 30. Non-helmeted riders injured in a crash has substantially higher healthcare costs than helmeted riders. In 2017, motorcycle helmet use saved Maryland nearer than $100 million in direct economic costs and nearly $600 million in comprehensive costs. When a non-helmeted motorcycle rider crashes and is injured, many are impacted and traumatized, not just the rider. This includes the EMTs who arrive on the scene, the nurses and doctors who treat and rehabilitate the patient, the families who now care for their loved one, or worse, say goodbye. the employer who has to replace a worker, the insurer who is paying the bills, and society who has lost a contributing member. Maryland has many public health laws and regulations to ensure safety while individuals pursue activities that are potentially dangerous and life-threatening. These laws are safety provisions that do not restrict the ability of an individual to participate in the desired activity. These include seatbelt laws, life vest laws, hunter wearing orange pink laws, seatbelt laws, cell phone laws, and speeding laws. We respectfully request an unfavorable report. Thank you.
Good afternoon. My name is Eric Teo. I'm the Director of Statistical Services with Insurance Institute for Highway Safety. So we made a lot of progress over the past decade or so in reducing death rates of passenger vehicle occupants, largely due to improvements in vehicle safety. But that unfortunately hasn't happened with motorcyclists. The research is very clear that helmet laws, those covering all riders, improve safety outcomes and reduce medical costs. The details are in my written testimony that I've submitted, but here are a couple highlights. When all rider helmet laws are weakened in a state, usually by exempting those riders 21 and over, helmet use drops from nearly everyone to about half. Rider head injuries jump, and crash deaths among riders increase 20 to 50%, sometimes more. Related health care costs also rise by about a third, and the public often shoulders a large portion of those. When states enacted all rider helmet laws, these forms of harms were reduced. We lose about 5,000 motorcyclists to crashes each year. That's a huge number. And with the well-publicized increases in behaviors like speeding and other harmful things among many road users, it's more important than ever to protect riders. And by the way, of those people killed in crashes, about 95% of them were at least 21 years old. So in summary, universal helmet laws are one of many straightforward rules of the road, as well as a highly effective public health measure. Retaining the existing law in Maryland would be in the best interests of riders in the state and of the state's finances. Thank you.
Chair Smith, Vice Chair, and respected senators. My name is Gary Schwartzbaum. I'm a neurosurgeon. I'm also the Medical Director of Neurotrauma Critical Care and Intermediate Care Unit at R. Adams Cowley Shock Trauma Center. And I'm opposed to the passage of Senate Bill 745. Patients arrive at shock trauma in a large, busy area called the Trauma Resuscitation Unit. There, the trauma attending on call carries a two-way radio where you can hear the incoming calls for help from all around the state. It gives me a great sense of pride to hear the attending say shock trauma online, because I know those three words are a lifeline to the patient. I also know when I hear the words motorcycle crash, that lifeline is even more critical. As a neurosurgeon, I'm sometimes called upon to take the skull off a swollen, injured motorcycle rider. The surgery, called a decompressive craniectomy, can be life-saving, but creates a large defect in the entire side of the head that is disfiguring and leaves the soft brain under the skin unprotected. If they survive, patients need to wear a protective helmet until the bone is put back months later, if ever. So you can wear a helmet now or you can wear a helmet later. As a critical care intensivist, I care for these same patients in the neurotrauma ICU, deciding on ways to treat their pain, making them comfortable on a ventilator, finding the best way to feed them and keep their bodies from wasting away, and succumbing to overwhelming infections as they often can't care for themselves. Among many such patients, I am haunted by a 10-year-old son, brought to a dying patient's bedside, asking innocently and repeatedly for his father to wake up, not knowing that moments before, our care team had discussed with the family that the patient would die despite all we could do. He was an illegally unhelmeted motorcycle rider that lost control of his bike. The foundations of Senate Bill 745 are predicated on false assumptions, as outlined in my written testimony. I'll end there. Thank you for your time and consideration.
Yeah, I'm just curious. So right now in the state of Maryland, it's legal to ride a bicycle on a roadway without a helmet. So people ride bicycles all the time on our roads out in Frederick County, the rural areas, and you don't have to have a helmet. So I'm curious, do any of your organizations, because, you know, we go through this every year, I put the bill in, people come down, do any organizations actively work on that law? To require bicyclists to have helmets? Because that's not currently required right now.
We haven't worked, this is the Brain Injury Association, we haven't worked immediately on that one, but we have worked on the one trying to get helmets onto horseback riders. This is a little bit different in that you're traveling at high rates of speeds and in traffic.
I mean, look, if somebody's running into me, I'd rather be on a motorcycle than on a bicycle. I think either one is not a good situation without a helmet, so, all right, so I'll put that out there. It sounds like the answer is no. None of you have come down and advocated for bicycle helmets on roadways then.
Well, I'm also a member of the American Academy of Pediatrics, and the American Academy of Pediatrics supports helmet use in children.
No, but well, I guess my point is, right now, there's this kind of interesting area in Maryland's law. If you're on a roadway, you can be on a bicycle, you can be right in front of my car and not have a helmet on. But if you're on a motorcycle, you have to have a helmet. And I guess that was my question, if any of you have come down and advocated on that issue. On the issue of the cost, which is brought up, what would you think would be a appropriate, not philosophically whether you agree with the bill or not, what is the appropriate amount if you were required an insurance rider, that they had to have insurance that cared for it? Would it be $1 million? Would it be a $5 million policy? I mean, because it was mentioned, you all testified, I forget which one of you testified to the cost of the medical insurance or nursing homes and all these. So it would be helpful to know, what is that cost that you're estimating it to be?
I was the one who testified on the costs, and the costs do go up when the helmet laws are weakened. We know that from research. But in terms of the issue of how much insurance, I don't have the answer to that. But I would point out that even when a rider or anybody is insured, as opposed to Medicaid or something like that, it still is others bearing the costs in terms of the other policyholders. So the costs don't just go away because somebody is insured, is my point.
No, I understand that, but if the idea is that they're a cost or burden to society, and we're assuming that they don't have health insurance, or we're assuming they're on Medicaid, which I don't always like to assume people's what insurance they're on or not, but I guess my question, would be helpful to know then, because it's testified constantly that this is a cost on society, I would like to know what is the estimated cost? Because if we were going to pass a bill and have an insurance requirement on there, you can't do that unless we have an estimated cost.
Yeah, Senator Huff, I'm sure the number's out there. It's about twice per unhelmeted versus helmeted. So the numbers, unfortunately, don't have that available to quote you, but it's about twice.
Twice what?
A helmeted, the total medical cost for an unhelmeted rider that presents to a hospital is roughly twice what a helmeted rider is.
Okay, thanks.
Thank you. And just real quick for the panel, this would be for any or all of you. I was curious to see if any of you actually have your own motorcycle or have a motorcycle endorsement on your licenses.
I do not currently ride nor have a license, but I did ride one when I was young in Pennsylvania. It's fun. I get that. But so is skydiving, but I don't skydive without a parachute.
I do not have a motorcycle endorsement on mine, but I've ridden in college as well, so younger.
Thanks.
Well, for a while, I thought I was the only one making the good jokes around here, but, all right. Further questions from the committee? All right. No, yeah. No pirate jokes from the panel, all right. All right, with that, thank you all very much. Thank you for your time today. Charles Greener. James Cannon. Allison Kemi. Allison Kennedy, and then Carla Oresco.
All right, good afternoon. My name's James Gannon. I'm the chairman for the Maryland Trauma Center Network, TraumaNet. I'm also the trauma program manager at the Baltimore City Trauma Center, and I've been an ER nurse and trauma nurse for about 14 years. I'm going to share with you two brief stories about what nurses experience all too often. The first is the 24-year-old male who 2 years ago fell off his motorcycle going about 30 miles an hour and was not wearing a helmet. He suffered a traumatic brain injury and is paralyzed from his chest down. He now visits our ER about 4 to 5 times a year for blood infections that he gets from his urinary catheter or the pressure ulcer that's eating through his buttocks. While we care for him during this 4-week hospital stay, his traumatic brain injury causes him to lash out at hospital staff, hitting us, scratching us, spitting on us, cussing at us, and yelling at us. We take it because we know his brain is severely injured, and he can't help it, but this still morally injures us. The second story, and I have my own picture, is the 44-year-old father of 2 who was out for a Sunday ride when a deer jumped out in front of him, causing him to be ejected from his bike, sending him sliding down 50 feet of asphalt road. The road acted like a grinder against his skull, shredding away the bone, exposing the brain. Bystanders are horrified and will never forget what they see. He is alive, barely, when EMS comes to get him. But on the way to our trauma center, he goes into cardiac arrest. Despite our heroic efforts, they're futile, and he passes away. I accompanied the trauma surgeon to notify his wife and 2 teenage children of this unexpected death of their father. Dad will not be coming home tonight. The trauma surgeon leaves, but I stay to console the family. They want to see him one last time, so I clean up the body, I put a pillow over the hole in his skull so that I can protect them from further trauma. I stay with the family while they cry. I suffer with them too, but soon another trauma comes in and I have to go back to work. But I still won't sleep well for a while. Both of these individuals would be alive and well today had they worn a helmet. As legislators, part of your job is to protect the citizens of Maryland from preventable harm, which is why I and TraumaNet ask you to vote unfavorable for this bill. Thank you.
Good afternoon. My name is Carla Oresco. I'm the lead nurse practitioner for trauma neurosurgery at our Adams Cowley Shock Trauma Center, and I am here to oppose Senate Bill 745. I've been in trauma nursing now for almost 30 years, and through my 30-year career, I have seen a lot of devastation that is related to not wearing motorcycle helmets. Not only does this devastation affect the patients, but it also affects their families, the healthcare team, and society. As Jamie said, there have been many nights that I've gone home and have not been able to sleep due to what I've seen for patients that have come in without wearing helmets. As has been stated before, we know that traumatic brain injury is the leading cause of death in motorcycle crashes. These patients are often admitted to the Shock Trauma Center, and as Dr. Schwartzbauer said, they do require surgery to remove a piece of their skull in order to allow that brain more room to heal, to swell and hopefully heal. So I find it ironic that many of these patients who do require that surgery are choosing not to wear the helmet while they're on their motorcycle, but now they need to wear a helmet simply to get out of bed. In 2020, there was 5,458 motorcyclists that were killed nationally. This was the highest number of motorcycle fatalities ever recorded. And in states without helmet laws, 57% of motorcycles were killed in 2019 not wearing a helmet, as compared to 9% in states with universal helmet laws. So the fact of the matter is, wearing helmets does save lives. Recent studies show that wearing a DOT-approved helmet reduces the risk of head injury by 69% and the risk of death by 42%. Motorcycle helmets also prevent $1.7 billion in societal harm annually. So again, I strongly urge that you consider these facts and oppose this legislation to prevent unnecessary injury and pain to all of the constituents.
Hi, good afternoon. I'm Allison Kennedy of Advocates for Highway and Auto Safety and a resident of Prince George's County. I appreciate the opportunity to testify today in opposition to this bill, and my testimony is submitted jointly with the Maryland State Council, the Emergency Nurses Association, the Partnership for a Safer Maryland, and the Skilled Motorcyclist Association, responsible, trained, and educated riders. Crash fatalities on our nation's roads are skyrocketing. Recently released data from 2020 revealed deaths across the country reached their highest level in more than a decade, with behaviors including speeding and impaired driving on the rise. In Maryland, fatalities spiked 6%, resulting in the deaths of 567 people. 85 were motorcyclists, which was an increase of approximately 10% from the previous year. Crashes impose, as you've heard, a significant physical toll as well as an emotional toll on Maryland families and come with a cost burden which is estimated to be approximately $6 billion. Especially at this perilous time on our roadways, repealing any of Maryland's laws, including the all-riders helmet law, which has been preventing deaths and injuries for nearly 3 decades, would be a deadly and costly mistake. Laws requiring all riders to wear a motorcycle helmet are effective and life-saving. Newly released data shows that in states with all-rider helmet laws, use was 86% compared to just 53% in states without such a law. Maryland's law is working to promote helmet use. In 2020, 16% of motorcyclist fatalities were unhelmeted. Conversely, in neighboring Pennsylvania, without such a law, the number was 57%. Experience from states that have repealed all-rider helmet laws demonstrate the deadly consequences of doing so. In Michigan, the year its helmet law was repealed, would have had 26 fewer motorcycle crash deaths if the law was still in place. And in Florida, the fatality rate jumped 21% after repeal. Moreover, minors-only helmet laws such as this one are not only ineffective, but they're also very difficult to enforce. To prevent more tragic deaths, debilitating injuries, catastrophic costs, and anguish of families, our organization urge an unfavorable vote. Thank you.
All right, thank you very much. Questions from the committee? Seeing none, thank you all very much. Thanks for hanging in there with us.
Thank you.
And with that, that'll conclude the hearing for Senate Bill 745. We'll now go on to Senator Huff with Senate Bill 300.
All right, well, thank you very much, Mr. Chair, members of the committee. Senate Bill 300 is aimed at helping victims of sexual assault. Often for a variety of reasons, state prosecutors will dismiss or not bring charges against an alleged rapist or abuser. This can obviously be crushing for a victim of sexual assault. Often they have summoned their courage to inform the authorities of their abuse. When a case like this is dismissed, it can both be bewildering and frustrating for the victim. Under Senate Bill 300, if a prosecutor decides against moving forward on a case, the victim will have the opportunity to request a meeting with the state's attorney. The meetings are aimed at helping victims better understand the reasoning for the case not going forward. At the meeting, the state's attorney will explain to the victims the justification for not filing a charging document or dismissing the charges. This will help the victim better understand why a potential abuser was not charged and will hopefully bring them a greater peace of mind about the judicial system. It's a pretty simple bill, 2 pages. Happy to take questions if there are any.
All right, seeing no questions, thank you, Senator Huff.
Thank you.
All right. All right, that'll conclude the hearing for Senate Bill. Is Lisa Jordan here? She's not. That'll then conclude the hearing for Senate Bill 300. We'll now move on to Senate Bill 893 and then 676. So if I could ask the Vice Chair to take the seat. All right, good afternoon, members of the Judicial Proceedings Committee, Mr. Vice Chair, members, Senator Smith here to testify on behalf of Senate Bill 893. Now, obviously, in this committee, we've had a lot of discussion, and we've made significant progress within the realm of public safety these last few weeks. We've passed for warrant apprehension, we've done absconding so that people make sure that they get treatment, judicial transparency, prosecutorial transparency, a jobs court, gun center, and some really good common sense gun safety legislation that's come through. And I believe that this bill is in that same vein of public safety. So before I get into the nuts and bolts of the bill, I'd like to thank my delegate, Delegate Janelle Wilkins, who came up with this concept and has really worked hard within the realm of public safety and finding non-carcerable solutions to our public safety challenges. So essentially what it does is it establishes a safer community fund, which would be administered by GOCAP. And the purpose would be to support robust and holistic investments in non-carceral, community-driven activity in public safety. So the funds that would be channeled through GOCAP would be used for mental health response programs, safety infrastructure, including lighting, also certain pilot programs that a municipality or a local jurisdiction could apply for. So again, any local government could be the grant recipient of the Safer Communities Fund, and if they were the recipient, they would have to establish a community advisory board, which would then help further suss out the details of how the money would be spent and act as somewhat of an oversight entity. This is not a novel or new concept. Crime prevention, these types of programs have been used in several jurisdictions: North Carolina, the city of Charlottesville, New York City, Kentucky, Louisville, Los Angeles, Seattle, Denver, Colorado have all implemented similar programs. And some of the examples, or some of the vignettes, would be crime prevention through environmental design, which, again, through design of buildings and lighting, can actually enhance the public safety prospect of our communities. Also, and I think you'll hear this from a councilman, from our Peter Kovar's here from our Tacoma Park City Council, mental health crisis teams. The money can be used for those as well. Mobile crisis teams, also known as the mobile crisis units, or home-to-home services, they can help address the problems with someone suffering from a mental health crisis, as opposed to calling for law enforcement officers. Again, you've seen this. It's not a novel concept, and it's proven. It's been successful. In a recent study taking place in Philadelphia, about 4% of calls for service involve violent crime, and approximately 65% of those calls don't need an armed response. So this will give us the ability to right-size our public safety response. Again, in San Antonio, 39% of the calls are the lowest priority level, with the vast majority pertaining to traffic incidents. So there are a lot of data surrounding how we need to shift our priorities so that we can right-size our response to non-carcerable solutions. And so with that, committee, I'd ask for a favorable committee report, and I'll turn it over to my panel. Excellent. All right. You can call the next witness, yes.
Sorry, happy to do so. Dominic Butchko and Peter Kovar.
I'm just going to wrap this off. You can say theirs.
Thank you very much, Mr. Vice Chair. Dominic Butchko with the Maryland Association of Counties. And I just want to say, this is my first time doing a session here in Annapolis. You are the first person, Senator, to pronounce my last name correctly, so thank you very much for that. But MACO supports Senate Bill 893. With the state currently facing heightened levels of crime, our counties welcome additional funding for deterrence and diversion. This bill fills a growing need to update safety infrastructure and modernize behavioral health interventions. Moreover, it will provide some relief to our overburdened local law enforcement agencies whose work is made more difficult by not having these alternative measures in place. Accordingly, MACO urges a favorable report. Thank you.
Hi, I'm Peter Kovar, council member in Tacoma Park, Maryland. Happy to be here, and I want to thank Senator Smith and Delegate Wilkins for putting forward this legislation, and thanks also to Mr. Butchko, and I guess that makes me the second person to pronounce his name right, also for expressing support for it. Tacoma Park is very supportive of the idea of establishing a fund for local level non-carceral approaches to public safety. And I think if you look around at everything that's happening, you see this is a growing trend to try to address public safety issues, not purely from a policing punitive perspective, but to also think about ways of addressing it that are more broadly focused within the community. And I will say that in Tacoma Park, as in a lot of places, we have gone through a process over the last 1.5 to 2 years on reimagining public safety. And we established a task force, and they composed of residents, and they gave us over 50 recommendations. And some of those are, to me, concepts that would really fit in well with what Senator Smith is putting forward here, and that includes, in particular, for example, people who can respond to mental health crisis situations, and the county is looking at that also. We hope to work closely with them. We're working on a plan also, though, to have a more comprehensive approach to access to public lands and parks, which is something that the senator just mentioned. And even when you look at equitable access to areas where there's more trees, which create better quality of life. And so we just think this is a logical step forward to help communities address public safety in a forward-looking, more holistic way. And I hope that the committee will report favorably on it. Thank you.
Questions for the sponsor or his panel? All right, seeing no questions, I believe that concludes the hearing for Senate Bill 893. We'll now move on to the chairman's next bill, Senate Bill 676.
All right, members of the committee, Mr. Vice Chair, Senator Smith here to testify on behalf of Senate Bill 676, Jalen's Law, which I've had before this committee for, I think, 3 years. I know we passed it out 2 years ago in the final days of session, and were unable to get it done last year. But before I get into the testimony and give a little bit of background of who Jalen was, who I understand is a constituent of was a constituent, and her family's constituent of Senator Bailey, I do want to just a little personal story. So, you know, this past drill weekend, the Navy and the military has put a strong emphasis on suicide prevention, and a core component of that is to ensure that all the service members are responsible with their firearms in their homes. And so they were giving out these trigger locks, and with a note and a hotline and information how you can seek help, but with the understanding that adding one more element, one step, can be dispositive of an outcome. It can change lives and it can save lives. So even the military has made this safe storage and of firearms a core priority for their service members. And so I thought that was kind of a timely reminder for the importance of gun safety legislation. Now, Jalen was a young, vibrant woman, high school student, who on March 20th, 2018, at the age of 17, she was murdered. So on March 20th, 2018, a 17-year-old student gained access to his father's gun and entered Great Mills High School in Maryland and shot and killed, she was 16 at the time, and also injured a 14-year-old boy. And a strong child access prevention law could have reduced those unintended shootings, and we know that 80% of school shooters obtain their firearms from their home or from their friends and from relatives. So in honor of her tragic loss, that's what the bill was named after, and it's been that way for the last 3 sessions. So again, we always talk about, well, what's the problem? Is it a national problem? Is it a Maryland problem? So I'll give you the Maryland numbers. Every town reports that the guns are the leading cause of death among children and teens in Maryland. And in Maryland, an average of 58 children and teens die by gun every year, and that 82% of these deaths are homicides. Now, in the United States, 50% or 58% of all gun deaths among children and teens are homicides. Now, the Education Fund to Stop Gun Violence for Maryland data also reports that in 2019, 757 gun deaths actually occurred in Maryland, including 59 in children and teens. And I could go on. But what I'll do is I'll walk through the bill and then switch it over to my panel. I think we have a lengthy list of witnesses in support. So Senate Bill 676, the Child Access Prevention, essentially it has a couple of core components. One, it prohibits storage of a firearm in a place where the owner knew or should have known that a minor could access the firearm, and or the minor does access the firearm, and or the firearm causes harm to a person. It provides an exemption in the case of a rifle or shotgun if the minor has a hunting permit, the minor has permission from their legal guardian to be handling the firearm, and that the firearm has been stored unloaded with any ammunition inaccessible to the minor, It also does not apply to a minor if the minor is supervised by an adult, the minor gained access to the firearm by unlawful entry, the firearm is in possession of an on-duty law enforcement officer, and it extends the current law, which includes new language from the bill, from applying to a child 16 and under to applying to a minor 18 and under. And so with that, Mr. Vice Chair and members of the committee, I'd ask for the committee for a favorable committee report.
Thank you, Mr. Chairman. Questions for the sponsor? Seeing no questions for the sponsor, if you could bring your panel up. Mr. Benjamin, Ms. Herron, Ms. Ladd, Woody Kessel.
Does it matter what order?
What's that?
Does it matter what order?
It does not. Camden Weber.
Sorry?
I was looking for Camden Weber as well. Come on up. All right, go ahead.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and distinguished members of the committee. I am Karen Herron, Legislative Director for Marylanders to Prevent Gun Violence. I'm here to urge a favorable report on Senate Bill 676 to require firearms to be stored inaccessible to minors and to establish an education campaign to provide accurate information on child firearm access prevention. This year's legislation, while notably similar to prior years, has a number of adjustments. First, it reorders the language to improve the clarity of the law regarding what applies to handguns and what applies to long guns. Second, it makes adjustments to the legal standard used when a gun owner has not adequately stored their firearm and a court is looking whether or not to hold the gun owner accountable. The standard utilized, knew, or reasonably should have known that an unsupervised minor is likely to gain access is mirrored in at least 11 other jurisdictions, which can provide guidance to Maryland courts while this law is in its early days. Lastly, this year's legislation adds an education component, which is to be organized and maintained online by the Maryland Department of Health. This material will focus on what safe storage looks like and the mandates the new law places on gun owners. Public education is critically important to the underlying purpose of this legislation, to improve gun owner storage habits and reduce entirely preventable child gun access shootings. Nationally, 8 children and teens are unintentionally shot daily in instances involving improperly stored or misused guns found in the home, resulting in injury or death. These are all entirely preventable incidents that you can do something about. We urge a favorable report on Jalen's Law, SB 676. Thank you.
Mr. Chair, Mr. Vice Chair, committee members, I am Peter Benjamin. I live in Garrett Park in District 18. That is in Senator Waldstreicher's district. I am a member of Marylanders to Prevent Gun Violence. Too often, we hear of a minor who takes a parent's gun to school and shoots classmates and teachers. We remember Sandy Hook. Too often, an angry minor uses a parent's gun to settle an argument with another minor. We remember Jalen. Too often, a despondent teen uses a parent's gun to commit suicide. We remember Sidney Aiello. Too often, a child plays with a parent's gun, not understanding that it is real and loaded and shoots a friend by mistake. This must stop. So I support SB 676 to legislate requirements for gun and ammunition storage. I urge a favorable report on SB 676 to keep guns away from minors. Thank you for giving me this opportunity to speak to you.
Good afternoon again. Chairman Smith, Vice Chair Waldstreicher, and members of the committee. Again, for the record, my name is Melissa Ladd, and I live in Olney in District 19. I am here in support of SB 676, Jalen's Law, and I ask for a favorable report out of committee. Firearms are the leading cause of death for America's children and teens. More than half of current gun owners do not store their firearms securely. 4.6 million children live in a home with an unsecured firearm. And 80% of school shooters get their gun from their home or the home of a friend or family member. Studies show that households that locked both firearms and ammunition were associated with a 78% lower risk of self-inflicted firearm injuries and an 85% lower risk of unintentional firearm injuries among children and teens, compared to those that locked neither. Another study estimated that if half of households with children that have at least one unlocked gun switch to locking all their guns, 1/3 of youth gun suicides and unintentional deaths could be prevented. Secure storage prevents shootings by disrupting unauthorized access to firearms. The bottom line is that it is adults' responsibility to secure guns to keep children from accessing them. We need to do more in Maryland to ensure that adults do all that they can to keep guns out of the hands of children. Next week, on Sunday, March 20th, it will have been 4 years since Jalen died after being shot at her school. In honor of her, it is time to pass Jalen's Law. Thank you for your time.
Good afternoon, Chairman Smith and distinguished members of the committee. My name is Camden Weber. I am the manager of state policy at the Brady Campaign to Prevent Gun Violence. Thank you so much for the opportunity to speak before you today on this really important law, and it's actually my first time before the committee, so it's nice to see you all. This bill will encourage responsible gun storage, and by doing so, it'll save lives by expanding Maryland's existing child access prevention law to ensure that fewer minors can and do access firearms. A 2018 study found that only 1/3 of parents are storing guns locked and unloaded nationwide, leading to a crisis of unintentional shootings amongst minors in their homes. And while many parents think that their kids don't know where their guns are or how to access them, the available data unfortunately shows otherwise. About 70% of kids report knowing where guns were in their household, and 1 in 5 parents who reported their child had never handled the household firearm were contradicted by their child. We know that a vast majority, about 3/4, of firearms used in unintentional shootings, school shootings, and self-harm by minors are acquired from their home or from the homes of friends or relatives. It's easy to read the statistics, but we must recognize the lives behind that data, like Jalen's. For the 5 most recent years for which data is available, 35 minors in Maryland used a firearm to take their own life, and almost 90 were murdered with a firearm. In just 5 short years, we've lost over 100 young lives that were taken by guns before they even had an opportunity to really begin. Similarly, data from the courts gives us a glimpse into many more cases where harm may not have resulted, but where negligent storage practices resulted in the unlawful access of a firearm by a child or teen. In 2019, Maryland courts logged over 150 violations under the current child access prevention law, and in 2020, there were another 90. What we know is that these cases are preventable, and research consistently shows that states with strong laws regulating the storage of firearms, may I continue? I'll wrap up. In households with minors experience significant reductions in firearm fatalities when compared to states with no such regulations. This law will ensure that more minors are protected in the state, and I urge a favorable vote on the bill. Thank you so much.
Afternoon, distinguished senators, and thank you, Mr. Chairman, and thank you, Mr. Chairman, for introducing and supporting this legislation. It's critically important. My name is Woody Kessel. I'm a professor of public health at the University of Maryland. I'm a former assistant U.S. Surgeon General, and I'm a pediatrician. I've dedicated my life to saving the lives of children, and not just saving them, but preventing untoward consequences that children, and you've heard from other witnesses, can suffer as a consequence. You know, as a pediatrician, I'm not only here supporting the memory of the tragedy of Jalen Willie, but I'm also here on behalf of the other 1.5 million children living in Maryland vulnerable, at risk because of unsecured weapons. I also want to thank Senator Carter for talking about safe storage in other settings as well. This approach certainly is protective as it was agreed, and frankly, there was joint support across diverse groups. Here, I'm hoping we'll achieve the same kind of thing. You know, although I don't know the personal pain of the Willie family, for the 5 decades of being a pediatrician, my heart aches for the children I've taken care of as a consequence of a preventable injury from the fatal exposure to firearms. We believe in safe storage. We keep our medication safe. We keep the toxic materials under the sink safe. We keep alcohol safe. We keep things safe from kids. It's part of our culture to do that. We secure our children in car safety seats. We place them in seat belts. A major important feature of this is added, and again, thank you, Senator Smith, you've added a public health approach, educating the public, taking deliberate steps, not just describing the problem, but trying to prescribe a solution to adolescent suicide and to unsafe storage in our community. So on behalf of the 1.5 million children in Maryland, I urge you to support this bill and a favorable report. Thank you.
Excellent. Thank you all very much for your time today. Questions from the committee? All right, seeing none. Thank you very much for hanging in there with us to the end of the day. I know it's been a long day. Suhani? Yes, Suhani, there you go. And up, Councilmember Kovar, come on up. And Larry Epps, Scott Tiffin. Is April Ferguson here?
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. For the record, my name is Suhani Chatalia, and I'm here on behalf of the Maryland Nurses Association. The Maryland Nurses Association is in strong support of Senate Bill 676. This bill is a common-sense policy that will encourage the safe storage of firearms to reduce youth access. Child access prevention measures can help reduce youth suicides and firearm-related deaths by ensuring that firearms are stored safely and in a way that is inaccessible to children. The Maryland Nurses Association recognizes that access to firearms is a public health risk and is a significant factor in youth suicides. When children have access to a firearm, their likelihood of death by suicide is significantly higher. When a home contains unlocked guns, the odds of a child or adolescent dying by a firearm suicide is more than twice as high as in households where guns are locked. The risk of suicide by a firearm is more than twice as high in households with loaded guns compared to homes with unloaded guns. Child access prevention laws are incredibly effective at preventing gun deaths and injuries among children and teens. Child access prevention laws can reduce suicide and unintentional gun deaths by up to 54%, with the greatest reductions occurring in states that already have safe storage requirements. The Maryland Nurses Association thanks Senator Smith for bringing this bill forward and urges the committee for a favorable report on Senate Bill 676. Thank you.
Thank you, Mr. Chair and members of the committee. My name is Scott Tiffin, and I'm here on behalf of the Maryland School Psychology Association, as well as the Maryland Assembly and School-Based Health Centers. In your testimony, there is a one-pager that has a list of behavioral health groups that are supportive of the bill. But I just wanted to highlight a couple points that I think are important from that group's work. You know, a lot of behavioral health providers typically don't get involved in a lot of firearm-related bills, but they really do see this one as an important suicide prevention mechanism to keep our young people safe. There's this report from the Department of Health, the Maryland Department of Health, found that 18% of high school students have seriously contemplated suicide in the last year. But probably more concerning is that about 16% of high school students had reported having a plan on how they would die from suicide. You can talk to behavioral health providers, we have some as well on our panel. Having a plan on how you want to die from suicide is a much higher risk factor than just having planned, or just having contemplated suicide. And so the fact that 16% of Maryland students were in that space is very concerning. Additionally, suicide is very linked to impulsivity, and it's often an impulse-driven decision. A study from 2007 found that nearly 50% of all suicides, these were nearly lethal suicides, the person reported that they had contemplated suicide for less than 10 minutes. And what that means is that if that person has access to a highly lethal means of suicide, such as a firearm, they're much more likely to die from that attempt. So the behavioral health folks really would like to see this bill move forward this year in order to protect all Maryland children from firearm suicide deaths. I'm happy to answer any questions. Thanks.
Thank you, Mr. Chairman and members of the committee. We are in the midst of a youth mental health crisis triggered by a tenacious pandemic. If there ever was a time to pass legislation to secure firearms from the reach of youth, this would be the time. As a past president of the Licensed Clinical Professional Counselors of Maryland and a program director at JPR Pratt, I can attest that our youth programs and mental health therapists across the state have seen a meteoric rise in depression, anxiety, suicidal thinking among youth over the pandemic. And while it's true that the Second Amendment gives Marylanders the right to bear arms, it does not give them the right to be reckless with those arms around children, especially during a youth mental health crisis. And this one bit of context is important. Even before this pandemic, our state's major city, Baltimore, was listed as the 4th most violent city in the U.S. and the 21st most violent in the world. And the research for why this is clear. The more unsecured guns you have in a community, the more suicide and violence you have in a community. If we cannot pass this small measure to prevent gun violence, what does this say of our indifference to violence? What does this say about our belief in the sanctity of human life? As a mental health professional, what I'd like to emphasize today is the understanding of the mindset of a youth in suicidal crisis. We know the intensity of mental anguish and suicidal thinking can be as excruciating as the pain of a broken leg. Youth in this state of mind, which the pioneering suicidologist Edwin Schneidman called psychache, because of its unusual intensity, predisposes youth to impulsivity and irrational thinking. In my 28 years as a mental health professional, I have learned the inconvenient truth that suicidal thinking is much more prevalent among youth than what any of us would wish to believe, and I have learned how vulnerable depressed youth is with access to a gun. Thank you so much.
Good afternoon to the chair and members of the committee. My name is April Ferguson. I'm a licensed clinical social worker with a background in child welfare. I'm also a member of the Maryland National Association of Social Workers. I'm here to support this Senate bill. Suicide prevention is critical to save lives. As social workers, we're often at the forefront of mental health and behavioral health services. We work with clients experiencing mental health crises, including suicidal ideations and suicide attempts. One of our roles when clients are at that state is to assess for safety, and we look at whether or not clients have access to deadly means, and we develop safety plans to ensure the welfare of clients during that time. We never want a manageable mental health crisis to turn into a tragedy. This bill is important because it spells out storage precautions that are important for minors experiencing mental health crisis. These precautions are vital to reduce risk to youth and also to ensure the protection of children and minors. Another part of this bill that stood out was the creation of the Suicide Prevention Guide and the Firearm Storage Safety Guide. Over the years of my career as a social worker, I've worked with parents who are supporting children with severe and debilitating mental health illnesses. This is often overwhelming to parents and the families that support these children. These families seek out social work services because they want to keep children safe and they want tools and resources on how to support children experiencing suicidal ideations. The creation of this guide and the easy access to this guide online is another tool for social workers for us to use to educate and inform clients on how they can keep children safe when they're experiencing mental health crises. This tool also empowers clients to make healthy decisions to properly and safely store their firearms. Social workers have always cared about the welfare of children and keeping youth safe. We hope for a favorable report of the Senate bill to continue to ensure the protection of children. Thank you for your time today.
Hello again, Peter Kovar, Tacoma Park City Council. Thank you to the committee for hearing our testimony, and thank you again to Senator Smith for introducing this bill. I think it's a really important one, and it's a common sense measure as I see it. Tacoma Park as a city is very supportive of it and urges favorable consideration. I note first of all that the bill only applies to storage and not to use of guns. And when you hear all the statistics that my colleagues have cited and that Senator Smith has cited also, it's very clear that whether we're talking about an accident by a young person who's handling a weapon without any sort of supervision, or the type of actual intentional killing that spurred the senator to introduce this bill, or the very compelling examples given by my colleagues, fellow witnesses here, in suicide. All three of those possibilities are made much more likely when guns are not properly stored. And I don't think there's a strong argument against wanting guns to be stored more safely and securely so that young people are not exposed to the possibility of dying either through accident, intentional killing, or suicide. And the data is clear that when a home contains unlocked guns, the odds of a child or adolescent dying by firearm is just much, much higher. And so the City of Tacoma Park strongly supports this legislation, and I urge its favorable consideration. Thank you.
All right, thank you all very much, and thank you for hanging with us. We have one question. We have Senator Bailey. Oh, are you good? Okay. Thank you all very much. Thanks for hanging in there with us. All right, so with that will complete the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and we'll start off with John Jocelyn, DJ Spiker, Mark Pennack, and Mike Doherty, and Michael Burke, if you're still here.
Mr. Chairman, Mike Doherty will not be with us tonight. He is unable to get off work. He has a national security type job, and they need him now. Good afternoon, Mr. Chairman. John Jocelyn speaking for 2A Maryland. We are not opposed to safe storage. In fact, we encourage it. We teach it in our classes. We teach it in the handgun qualification license class. In point of fact, we have taught over 241,000 Marylanders about firearm safety since 2013. Our problem isn't so much with the bill, but in the way it is implemented, in the technical language that's used, and the lack of definitions. For example, I have given every one of my HQL students a cable lock identical to the one that Chairman Smith showed us. They're available for free through the Child Safety Program. They work. The problem is they do not qualify under the terms of this legislation. They do not prevent access. They cannot be used on a loaded firearm. The details matter. Words matter. Definitions matter. We have 250,000 people who think they will be in compliance with Maryland law when in fact they will not be. This is a major problem. You cannot legislate safety. You can only educate. You can't force people to do it. You simply show them the information, give them what they need, teach them, encourage them, but legislation won't cause safety. And that's the failing with this type of legislation. It puts a mandate on people with penalties if something happens, but in point of fact, it really doesn't stop it from happening. How many times have you seen a bust where a drug dealer went down, firearms are left unsecured in violation of existing law? and they are never, ever charged. We need to educate, but we don't need to legislate. We urge an unfavorable report, and Mr. Chairman, thank you for bringing that lock in. I forgot mine.
I've got extras if you want it.
Please.
Okay. All right. Please, thanks.
Mr. Chairman, Mark Pennock, I'm the president of Maryland Show Issue. We're not writing on a blank slate here. Maryland is one of the minority of states that already has a safe storage law in Section 4-104 of the criminal law article. So it's not an issue whether or not guns should be secured. They are already required to be secured. Now, I have in my written testimony before you a long list of legal objections and problems with the current wording of this legislation. But I think the bigger problem here is not penalizing with severe penalties, increasingly severe penalties, but to actually secure compliance with existing law. I will say unequivocally that Senator Carter's bill, 773, that you heard today, as amended, will do more to secure compliance and the safety of children than anything in this bill will ever accomplish, because it provides a financial incentive for people to acquire the safety material that will secure these firearms. I believe in security of firearms. I teach it. I'm an instructor. So no one is opposed to securing the firearms. But what we would like to see is legislation that, Senator Carter's, that will actually secure compliance with existing law. This state does not need more severe penalties. It simply needs more compliance with existing law. I urge an unfavorable report. Thank you.
Chairman Smith, Vice Chair Waldstreicher, DJ Spiker at the National Rifle Association. Similar to what Mr. Jocelyn indicated, we have concerns about the language of this bill, certainly concerned about the lower standard for prosecution, changing the existing word of would to likely to. Likely to is far broader than would, and certainly have concerns about the overbroadness of that language standard. In terms of vagueness, tamper-resistant is what we're referring to in terms of the lock. The only other instance of a reference in Maryland Code to tamper-resistant is to a smoke detector. We do not know what a tamper-resistant lock means. A Google search will find you a window tamper-resistant lock, not necessarily specific to a gun or a safe or a lock device, as the chair brought in. Similar, what Mr. Pennock said, existing code section does apply here. And recent code has been applied in addition to the existing code of 4104, referring to 3-204, leaving recklessly is applicable to this, to exactly the area we're talking about and is currently being used in case law. That penalty is 5 years and up to a $5,000 fine, larger than this. Lastly, specific to the penalty, similar to what we addressed on some of the earlier legislation this cycle, a violation of the second area of this new language would result in a 3-year penalty and trigger a federal prohibition for a lifetime of your federal firearms rights. And again, at a minimum, that should be changed to 2. It's easy to anticipate a situation where in a broken home or a separated situation where there's a tragedy involving a minor and that spouse or their partner is unable to access a firearm to protect themselves in their home. So we certainly would urge an unfavorable report. Thank you, Mr. Chair.
Thank you, gentlemen. Real quick question. I know when the proponents were testifying, they were saying that the accidents are much more, much higher chance of an accident happening when you have an unsecured firearm in a home. And I don't disagree with that statement. But what I'd like you to do is, I know that in Maryland, and I've been a part of it for a long time, is that's education of children. And I know we just passed in 20 years of all the children that had been educated, that there hadn't been one accident, right? With all those children that had been educated. And my question to you is, I know there's a lot of states that mandate education for children, hunter safety. It's coming back all across the country, especially in the Midwest. And a big part of that is safe storage safe handling, about how to do it, and they teach their children. Because the thing is, a lot of the kids that were running into problems with firearms weren't just in their house. They were finding them on the street. They were finding them, they were illegal firearms that they were uncovering. And I'd just like your opinion on the fact of, and what you think about if we looked at mandatory education for children.
Senator, if I may respond to that. I think mandatory education is a great idea. The NRA, for example, has the Eddie Eagles project that talks about safe storage. That's a great program. It should be implemented more broadly. Guns, I teach my children how to act around firearms. I teach children, because under Maryland law, you can actually teach children with the possession of a handgun, for example, instruct them in the safe handling. I'm all for education, because that is the best guarantee of people who will handle firearms responsibly and will know about them. So I don't oppose, for example, suicide protection programs, such as some of this is outlined in this amendments to the Health General article in this. That's also a worthy educational effort. We're all in favor of education. That is the best way. So if you just enforce existing law and you educated the children and the parents about safe storage, you will have an impact. But right now, people are simply aren't willing to do that. Now, I find that regrettable.
Thank you.
Senator, if I may, back in the 90s, one of my efforts was to have an Eddie Eagle Safety Day declared in the House of Delegates, which did happen. I think it's interesting to note on page 5 of this bill, it makes reference to organizations that would receive the safety brochures. It makes no reference to HQL instructors, concealed carry permit instructors, natural resources, hunter safety instructors. None of these people who have direct contact with firearms owners, far more than any of these agencies would have, they're noticeably absent in the language of this bill. So yes, you are right. We need to reach out, we need to educate, but this bill doesn't do it.
Okay, thank you.
All right, seeing no further questions, thank you all very much. And with that, that will conclude the hearing for Senate Bill 676. Thank you all very much. All right, so we've got voting. Let's give a 20-minute break. We'll recess for 20 minutes. Do you think it's enough for people to get something to eat and kind of reset real quick? Or do you want? 20 minutes? Yeah, half an hour?
How long do you think we're going to move?
I'd say an hour.
20 minutes, you're not going to get something to eat. There's nothing even.
Yeah, fair enough. Yeah. Yeah, okay, so let's come back in 1 hour. 1 hour. Okay. 6:25.